I've already passed an order in respect of another matter. I am covered by the same judgment. If not taken up today, Milord, kindly take it up tomorrow, anytime, Milord. Item number 44.
Negative marking, I have already passed.
Yes, Milord.
So they can participate, but result will not be published. So that will cover all the candidates.
Thank you.
No, sorry. Yes.
Your Lordship, may I be permitted to mention one matter for non-prosecution? Your Lordship, the petitioner has...
There is not a date for mentioning. Mention on Monday. Yes, please call the list.
Yeah, your
Sorry,
Lordship.
no.
The only thing is
No,
that
no further mentioning.
the mothers,
No
people are
further
not
mentioning. Sorry.
Lordship,
Yes, please call the list.
appearing in the board examination.
Please call the list.
Item number 1.
Examination is on
I am
10th,
for the petitioner, Lordship.
10th February, my lord.
Private respondent number 7.
I am for the private respondent number 7.
Who is for the petitioner?
I am for the petitioner, Lordship.
Yes, what do you want?
Lordship, I mentioned the matter several times for fixing the date as from 2nd January.
That is but I have disallowed your mentioning
Yes,
for
Lordship.
accommodating the matter in the supplementary list. Now you want the
Yes.
matter to be released.
Yes, Lordship.
Yes. Matter has come up in the list under the heading to be mentioned. On being mentioned by the learned advocate representing the petitioner. Stop. Petitioners. Stop. Matter was, next paragraph. Matter was previously mentioned on urgency for accommodating the matter in the list under the for accommodating the matter in the supplementary list. But court was not satisfied on urgency and the prayer of the petitioner was refused. Stop. On behalf prayer of the petitioners was refused. Stop. On behalf of the petitioners, further prayer was made to release the matter. And accordingly, matter is appearing in today's list. Stop. Next paragraph. As prayed for on behalf of the petitioners, matter stands released and be placed before the Honorable Chief Justice for assignment.
Grateful, Lordship.
Item number 2.
Date of superannuation, year, my lord.
Yes.
Petitioner, my lord, retired on, my lord, 31st December 2009 instead of, my lord, 2019.
Issue. Matter has come up in the list under the heading to be mentioned. On being mentioned by the learned advocate representing the petitioner for correction of the order dated 11 December 2024. Next paragraph. In the second line of second paragraph of the first page of the order dated 11 December 2024, date shall be read as 31st. The year shall be read as 2009. The year shall be read as 2009 instead of 2019. Stop. Next paragraph. Department is directed to incorporate necessary correction. Stop. Let this order be treated as part of the order dated 11 December 2024.
Item number 3.
But in this matter, I am for the pitch. That is,
I appear on behalf of the state, madam.
but this matter pertains to general transfer of the petition. Petitioner applied in the portal, but refused on the by the HOI on the ground that petitioner not come under the zone of 10%. But my case is, my lord, I am very much within the 10%. So,
এইটাই তুমি আসো নামটা দিয়ে দাও দুজনের নাম লিখো আমার নাম আর ওর নাম দুজনের নাম দেখো আইটেম নাম্বারটা লিখো
Yes, yes, what you are submitting?
my lord, I am submitting, lord, when I applied in the portal at the relevant point of time, there are 22 assistant teachers in the school. If 10% rule applies, 2.2 fraction to be treated as a rounded to next highest degree, 3 teacher can got NOC
How many teachers are working in the school?
at the relevant point of the 22.
In which year?
In the year, my lord, 2021.
in the year of 2021
And thereafter, there was no transfer.
Only, my lord, 2% got NOC from the school, 2 assistant teacher, Tripti Borai and Amita Shatpati. And Tripti Borai ultimately transfer effected, but so far on Amita Shatpati's case is concerned, it has been returned back by the authority. So one teacher, ultimately one teacher got transfer effective.
Oh my, this is wrong submission.
This is my instruction, my school is there.
Yes,
Two teachers have been
out of
out of 22
two teachers have been transferred.
and two teacher on general transfer and two teacher on
So now
medical-
the number of teaching staff is 20.
21
no
and 22
at present 18
18,
18
1 8.
1
Now, after transfer of two teachers,
yes my lord.
so you are saying that there were 22 teachers
Yes
in 2021. So out of 22 teachers, if two teachers took transfer, in that event, the teaching strength would come down to 20 from 22 to.
and two teachers another two teachers were also transferred on medical ground.
So on general ground 2, on medical ground 2. So it comes total 4. So the strength comes down to
At
18. 18.
18.
Is there any fresh appointment?
No.
My lord,
Six
as per
vacant
10%
six
subject to
I have delivered a judgment.
six
So
vacant-
yes, no. Unless and otherwise, there will be gradual depletion of teaching strength. If in every academic year this 10% rule would apply, then 22 it will come to 20,
Yes, yes.
then it will come to 18, then it will come to 16. But there will be there is no replenishment.
May I reply? My lord, it is not a case that first lot, I have applied in the first lot very beginning. If 10% rule is applied in the first application, first lot of application, 3 teacher can get on in general ground.
But that is not a subject matter of challenge in this petition.
Yes.
Now whether you can
Now,
challenge, they have already taken transfer.
No, my lord, kindly, my lord, my lord, kindly visualize this case. When 22 teachers at the time of Utsos,
When this decision was taken that instead
21.
of 3, 2 teachers were permitted to take transfer.
21, first step.
So why you did not take challenge the decision of the managing committee of the school?
Yes, that is delay.
So then now it
I
has
have challenged
now it has become the issue has become stale in the meantime.
No, my lord.
No,
delay.
the issue is not issue does not survive now. Now you are simply you have you have filed this writ petition praying for a direction upon the school authority to forward your transfer
Yes.
application.
My lord,
That is not
one
possible
quota-
at this stage.
one quota is late.
Your transfer application is dated 13th August 2021.
Yes, my lord, one quota is still left. One quota, 1% can, my lord, 10% if 22 teachers simply arithmetically 22 teachers.
Then you file a report
Lordship.
disclosing the staff pattern.
Yes.
Then it will.
I shall also file and give me liberty exception if any.
Matter is heard in presence of the learned advocates representing the parties. Stop. Petitioner prays for transfer on general ground, transfer on the ground of distance based on her transfer application dated 13th August 2021. Stop. However, the learned next paragraph. However, learned advocate representing Shirampur Shirampur Uttoma Sundari Girls High School within bracket HS District Purbo Medinipur being respondent number 5 submits on instruction that out of 22 teachers, 2 teachers took transfer on general ground and 2 teachers took transfer on medical ground. As a result whereof, teaching strength of the school has come down to 18 from 20 from yes from 22 come down to 18 from 22. Stop. It is also submitted that in the meantime no appointment has been made in the school. Stop. Next paragraph. The learned advocate representing the school authority is concern and respondent number 5 is directed to file a report in the form of affidavit disclosing the present staff strength, disclosing the present staff pattern of the school, and also to disclose in 2021 how many teachers were working in the school, and out of those teachers, the number of teachers who have taken transfer. Next paragraph. Let such report be filed by 2 weeks from date. Next paragraph. With an advance copy upon the next paragraph corona with an advance copy upon the learned advocate representing the petition. Next paragraph. List the matter under the heading motion on 27th February 2022. 2025. Yes.
I am extremely great.
Item number 4.
For the commission. Pursuant to your lordship's last order, I have served notice upon the school authority and they have received.
Yes.
But I paid for transfer from Jhargram to Bakur. Number on 13 July 2022, I applied through Utsoshi portal. But since after my application, the Utsoshi portal was suspended. Number I have made a subsequently offline application, and that is pending. But my prayer for transfer is on my lord gynecological disorder. My lord, if you also kindly come to page 22 first. This is my first application to the Utsoshi.
It is dated
13th July 2022.
It was on medical ground.
It was on medical.
Self-medical ground.
Self.
Now this was now the application is lying before which authority?
Number the Utsoshi portal is closed thereafter.
Yes.
Next page, now page 23, I made an offline application.
No, you have to offline application unless until it is extremely unless until it is a special case. The court is not allowing offline application at present.
My lord.
Now, since you have applied on Utsoshi portal on 13 July 2022, you need to apprise this court that where the application is lying.
Now it will be on the end of the district inspector of school because Utsoshi portal is
That you need to apprise this court. Who is appearing for the state?
last August no one appeared.
No, whether the school has forwarded it to the DI district inspector of schools or not.
I applied within 2 to 3 days before school forwarded it to the DI. Utsoshi portal.
No. 13 July 2022.
My lord.
In portal was suspended on and from 29 September 2022. You do not know the position. Completely wrong submission.
My lord, it was
Even if the teachers who are who made application 2-3 days prior to suspension, court is passing order.
my lord,
Your case is better so far your online application is concerned, but you have to apprise this court that where your application is pending, where your application is stuck.
it is not shown in the website. It is not shown in the
You don't have to obtain instruction. Unless and until it is extremely urgent in terms of medical emergency, court is not passing any order on online offline application.
Right.
Suppose a teacher is suffering from cancer
yes, madam. Then
or
kindly
acute
give me-
or gross
kindly
disability.
give me 2 to 3 days so that my client go to the office of the DI and we can. Now, my lord, if you so want, I can serve further.
Petitioner affidavit service filed on behalf of the petitioner is taken on record. Stop. Petitioner prays for transfer on medical ground. Now, petitioner made application for transfer on medical ground on Utsotsi portal on 13 July 2022. And in support of such submission, document at page 22 at page 22.
He has stated that on medical and distance.
Both.
Document at page 22 is relied upon. Stop. However, today petitioner is unable to apprise this court where the transfer application which was made online is pending. Or কি বললাম sentence টা একবার বলো? Court apprise this court before which authority online transfer application is pending. Stop. The learned advocate representing the petitioner prays for accommodation to obtain instructions. Next paragraph, list the matter under the heading motion on or list the matter under the heading motion in the monthly combined list of February 2025 in order to enable the learned advocate for the petitioner to obtain necessary instructions.
My lord, instead
Affidavit
of,
service filed on behalf of the petitioner is taken on board.
my lord, instead of
No, it's not
monthly-
possible every matter to be accommodated. in this
My lord,
affidavit.
kindly consider. I'll take
Sorry.
maybe 2 to 3 days. My lord.
No, sorry.
My lord, kindly, my lord, don't put it in the monthly
Yes,
list of
please,
February.
next matter.
Item number 5.
I beg to appeal.
Yes.
Maladi, all the petitioners are Maladi TET qualified 2015 and thereafter Malad participated in the first SLST Malad recruitment 2016 Malad. And Malad, but they
All
have
petitioners participated in
Malad SLST Malad, first SLST 2016 Malad.
under which category?
Malad, which category Malad this similar
Which SLST? There are several
16,
SLST.
16. Upper primary.
Yes.
Malad, thereafter Malad, they have not been called for interview.
Have you uploaded your testimonials in the second
My
phase
lord,
of
my lord.
selection process which started from Rule 12 to stage?
My lord, I have uploaded all my testimonials in this online.
When you have uploaded?
My lord, at 32 minus page number onwards. My lord.
On which date this uploading was done?
My lord, uploading done, my lord. This date was in the year 2016, man. On that within
This second phase uploading was probably done in 2021. 2021. Where is the uploading of materials or your uploading of testimonials in the second phase of selection process?
second phase, no, first phase, second phase, uploading and
In 2016, that gone.
My-
That procedure was abandoned by the dint of the order of the coordinate bench, and the coordinate bench directed the commission to initiate fresh selection process from Rule 12 stage. That therefore, in order to participate or in order to be considered in the said selection process, the candidates were required to upload their testimonials again in 2021. Unless until you have done this, your candidature cannot be considered.
My lord, I have, my lord, all this. My lord, if your lordship, my lord,
Show me that in 2021 you have uploaded your testimonials.
my lord, I will show, my lord. I have, my I will show, my
When you will show?
My lord, if your lordship, my lord, giving me opportunity, my lord, by supplementary FD.
Why you have not indicated this? It's a very pertinent issue.
Yes.
Have you stated in your affidavit writ petition that you have uploaded your testimonials?
I have uploaded it.
Tell me any whisper in your writ petition that you have uploaded the testimonials in 2021.
But I will in my
Yes, Dr. Patra, any say, instruction you have received? But there is no uploading.
Whether they have participated in the second round or not, there is not anything which indicates so.
Then,
my lord, I will, my lord, file
Sorry.
supplementary FD. In court.
petitioners have approached this court.
My lord, kindly, my lord, giving me, my lord.
Filed on behalf of the petitioner is taken on record. Next paragraph. Petitioners have approached this court with the present writ petition in order to grant them praying for opportunity to be considered in the selection process, that is first state level selection test within bracket upper primary close bracket 2016. Stop. On query being made to the on query being posed to the learned advocate representing the petitioners whether petitioners uploaded their testimonials in the second phase of selection process, which started from 12 to from rule which started from rule 12.2 stage in 2021 in terms of the order of the coordinate bench. Satisfactory reply is not received. Stop. According to the petitioners, they uploaded their testimonials in 2016, but nothing has been shown in support of their uploading of testimonials in 2021. When concerned authority of the West Bengal Central School Service Commission initiated the selection procedure afresh as per the order of the coordinate bench. Next paragraph. In view of aforesaid situation, no relief can be granted to the petitioners. Hence, the writ petition stands dismissed. Next.
My lord, may I be given opportunity to supplementary affidavit, my lord,
Oh,
to
sorry.
cure, my
Yes,
lord, this.
sorry. Yes, sir. Next matter.
Item number 6.
Matter of which I want to know.
Why? What prayer you have made? Regularization?
Mistake of the prayer person lost it on the ground. I want to enjoy it and
Modification of approval of appointment after retirement.
after retirement,
Where are you working in the school? Yes. When you are appointed?
1992 lordships.
Yes.
1992 on the basis of the description report lordships.
Organizing teacher.
Organizing teacher. From the inception, I am what?
Now you are the approved staff.
Approved.
Now, if you retire from the date of your appointment, then you would not be able to complete 10 years of qualifying service. And you won't be able to get the retirement dues. So now you want to prepone your approval of appointment from an anterior date. That's why you have chosen a very wrong court. What?
No, I am not saying anything, lordships. Lordships, earlier writ petition was filed on that ground, approval of the petitioner concerned. Subsequently, the earlier court first and order, considering the 4/3/1992, approval was granted since 2013, and the month by month salary should be
Yes, sir.
but that was not
At the time of call, learned advocate representing the petitioner prays for leave to withdraw the writ petition. Prays for leave to withdraw the writ petition. And also prayer is made to permit the petitioner to file afresh on self-same cause of action. Next paragraph, respondents are state, you are for the state, Mr. Haldar.
Yes.
State respondents are represented by learned advocates. Next paragraph. Considering the aforesaid submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn with liberty to file afresh with better particulars, with liberty to file afresh on self-same cause of action with better particulars. Next paragraph, parties shall act on the server copy of the order duly downloaded from official website of this court. Next.
Item 7.
For the petition.
Yes.
There are 53 petitioners. They are working as para teachers. Now in 2016, they uploaded at a point of time when their training was not completed. Because their training was completed in 2019. We are today, before your lordship, is also not asking for training part. So our uploading was done for 16 from
For which selection process?
for selection process of first SLST.
Upper primary.
Upper primary.
Now, only one thing, I just, the service possibly is not complete. We have not been engaged in this matter yet.
But I understand it.
It's not yet received by the commission.
Well, this commission is a necessary party. Let them obtain
I
instructions.
can here and now I have a copy I can give to my land.
There is no urgency in this matter.
There is no urgency.
So let me fix it up in the month of February after my coming
May I
back.
just point out so that it's a question of like yesterday's matter. There is in 4
Yes, yes.
subjects. May I just say so that my learned friend can take just here and take, because now 10% earmarked for the para teachers. There is no quarrel about any of the sides. From 16 to 24, for 90%, there has been several litigations, so many directions, all are affected, for which I am not concerned. I am only concerned
10%.
only 10%. Now they have issued a notification giving details of number of vacancies. Today, before your lordships are 53% spread over to only 4 subjects. In paragraph 12, I have given exact chart that this is the total number of vacancy. For an example, in Arabic, the number of vacancies are 36. There is not even a single trained persons. Just like in yesterday's situations. That's the situation in Sanskrit and pure science and bioscience. I have said that this is the total number in paragraph 12. Clear cut. This is the total number of vacancies. As per your list of trained persons, this is much less. This is the extra. We are already there. Kindly also accommodate us. So that
Beyond 10%, that will be within the periphery of 90%.
Within 10%.
So you are the petitioners are all untrained candidates.
I have to say untrained because at a relevant point of time, I was untrained. Our session for training started 15-16. Today we are trained because the state government took a delay. So I don't want to claim that part because that's not the subject matter in this petition.
So your contention is if appointment of untrained candidates in absence of trained candidate is no bar.
Yes.
In that case, let the untrained para teachers be accommodated
Absolutely.
against the vacancy.
Yes. And there are 4 subjects paragraph. My learned friend can.
Suppose there are 10 vacancies.
Yes.
No, I've
10
understood
candidates are
what
there.
my
Yes.
friend
Yes.
is
That I
saying.
know
would
you have
not happen. I will have to oppose.
Yes. Yes, very well. Come back with an instruction. Yes. Matter is heard in presence of the learned advocates representing petitioners, state respondents, and West Bengal Central School Service Commission. Next paragraph, Dr. Sudhanu Patru, learned advocate representing representing the commission, has prayed for accommodation to obtain instructions, and it is also submitted. Perhaps
Paragraph 12, I have given the chart.
It is also submitted that perhaps notice of this writ petition has not been served upon the.
All right, it is handed over today in the court.
Yes, copies I have received just now.
তাহলে ওই কথাটা লিখুন কি বলছিলাম
My lord will kindly excuse me.
Yes, to obtain instructions. Stop. Opore the affidavit service you are filing today.
Yes.
Affidavit service filed on behalf of the petitioners is taken on. Next paragraph. A hearing of this matter stands adjourned till 25th February 2025 in order to enable the petitioners or hearing of this matter stands adjourned till 18th February 2025 in order to enable the learned advocate for the commission to obtain instructions. List the matter under the heading motion. List the matter under the heading motion. Yes.
I have absolutely fine. Only thing, till today they have not declared the date of the personality test. In case they do it before 18th, my lord, I would
Stop.
mention.
Liberty is granted to the petitioner to mention the matter before the appropriate before the available bench in the event of any emergent situation.
Keep your-
Item number 8.
I have brought the state bylaw.
Similar prayer. So you want change of date of your approval.
Similar prayer I am saying.
ওইটা করে দেবে dismissed as withdrawn যেটা করলাম state respondents represented dismissed as withdrawn. Yes, same order. Same order.
Appearance study.
Item number 9.
On 9th January 2025. Direction to the
Just a minute. Yes, who is for the state? Yes, last occasion he appeared.
We pay for some time to.
Will serve notice. I am just you inform the learned advocate representing the state respondents, not today. It will retain its position. No, today is not possible. Yes. Not today.
কালকে করে রাখো।
I'm appearing for the state respondent, led by Mr.
Same order, dismissal with liberty to file afresh. Same order, dismissed as withdrawn with liberty to file afresh with better particulars.
হ্যাঁ নাম দিচ্ছি dismiss withdraw liberty.
Item number 11.
Being led by Mr. Sudipto Dasgupta.
Yes.
This is that matter, 12 RLC matter, Lordship petitioners have got the appointment letter, they have joined the school, now they are claiming for notional lordship.
Where is Mr. Dasgupta?
My senior is engaged in the matter in courtroom number 19.
Yes.
Similar order which your Lordship has passed is annexed.
Now, where is the order of the principal secretary? Granting notional incremental benefits.
Lordship, page number 28. In another matter, Lordship, the principal secretary had, by reason
Now, my first query is, were you a party before the principal secretary?
Lordship, Lordship, this is the first time we have approached for
Whether before the principal secretary your matter was considered?
matter considered was when the matter.
Please straightway answer the query of this court. If you do not know, pray for time. Before the principal secretary, whether your matter was considered or not.
No, Lordship.
My lord, one order is there, my lord. না এটা অন্য রেসিপি না এখানেই
I want, because there are two sets of orders, please don't make it complicated. whether your matter was considered by the principal secretary or not.
না না ভাই, এই তো প্রিন্সিপাল সেক্রেটারির অর্ডার অন্য, এটা একটা কমন অর্ডার। আমি জানি ম্যাটার তুই দিয়ে আমার কাছে আছে, প্রচুর মামলা আছে। এই কটা ম্যাটারে এই অর্ডারটা পাস করেছিল, রিজাইন করছে। সব ডিসপ্লে লাগে তো কোর্ট পাঠিয়েছিল।
Lordship, I pray for some time, Lordship, my senior
It's not today.
Lordship, all the matters,
Yes,
Lordship, from item number 11.
several matters are there.
Several matters.
Up to 36.
Lordship, if Lordship would
Not today,
grant a
today
pass
also.
over, Lordship, my senior would come and appraise you, Lordship.
No, today there is a
Philip to
difficulty.
Court number 19.
প্রমাণ দে কনস্টেবল সেটা করেছে
Whether the petitioner was granted notional incremental benefits.
বলে
Lordship, the earlier matter which your Lordship had.
I will collect your Lordship in the matter 85 writ petitioners filed together. Your Lordship directed that you choose one. Mr. Dajgupta was appearing, he chose for one, and your Lordship directed separate writ petitions for others. So, well, these are those separate petitions.
Yes.
Praying for Notional.
Lordship, they have been called for hearing, Lordship. Now the reasoned order has not been passed.
Where is that order which I have passed in the first writ petition?
It is page 30, yes, 36, na? 30, yes, page 33. And the relevant part is at 36.
Page 30.
Page 33, page 7.
এই বার করো তো 22309 of 2023. 22309 of 2023. কোথায় ছেলেটি আসেনি আজ?
কেন আছে তো অর্ডার, কেন বার করবে কেন? অর্ডার আছে,
Order is annexed.
তাও মাইলটের একটা
Separate order is required.
ও কারেকশন।
Oh, it's for.
You are thinking from your point of view.
No.
You need to think from my point and
I can't think from your lordship.
ইয়েস সিমিলার অর্ডার রিভার্সড
এই আছে বার করছো না?
Lordship, on the 9th, he was called for hearing, Lordship. Now the order has not been passed.
But even day before yesterday also another matter similar.
They were parties before the principal secretary.
Yes. That is 30933 of 24. Order.
Purab Noskod was followed.
This is Onamika Mondol.
Purab Noskod was followed in other.
Order your Lordship passed in the paper.
এটা কালকে হয়েছে?
এটা 14 তারিখ। Purab Noskod need 2068.
This was the first matter in the in a writ petition of 85 petitioners.
Yes. I don't remember whether that petition is the first one, but your Lordship directed to choose
That's
one.
fine.
He chose it.
Purab Noskod take the first.
না না না, গৌরবটাকে দেখে এটা করেছে। এই তো দেখ
দেখেছিস তো?
He was petitioner number 15 in 25 writ petitions. In a writ petition of 25 petitions.
So that I don't remember the sequence.
সিমিলার অর্ডার তো
এটাই ভুল।
হ্যাঁ ওভাবে এটা অনেক ভুল। 11 থেকে 36 হ্যাঁ অনেকগুলো বার করছে হয়তো। তাহলে কি করে হলো? বলছি দেবব্রত বিশ্বাসেরটাও চুজ করেছে। আমি তো দেখলাম ঠিক নয়, পিটিশন
বাকিগুলো এক্সপেন্স করেছে হ্যাঁ তখন নামটা থাকবে কি করে এক্সপেন্স গুলোর নাম থাকবে ফার্স্টে দেখ বাকিগুলো এক্সপেন্স কিছু দিয়েছে ফিফটি তো দেবো কত দেবব্রতটা আমি চুজ করেছি বলে যে দেবব্রতটা থাকবে বাকিগুলো এক্সপান্স দেখ নাই হ্যাঁ
Now tell me, what is the date of appointment letter?
My lord, in the first week petition.
appointment
Better strike off the appointment letter because in
Appointment
all the matters,
code of
these appointment
secondary.
letters are required to be indicated.
yes
My lord, appointment.
date to be
Yes, it's not required. Wait.
ওটা তো অ্যামেন্ডমেন্ট হবে না, অ্যামেন্ডমেন্ট করতে হবে না।
ওর ব্যাপার বুঝে নেবে
কিন্তু অ্যামেন্ডমেন্ট ফার্স্ট আইটেম অ্যামেন্ড করতে বলেছিল কিন্তু বেরোলো না।
Now, in all the matters, date of appointment is required. So tell me the date of appointment in this matter.
My lord, the date of appointment is 24/11/2020.
Yes.
24/11/2020.
আরে এখানে চেক করে নিচ্ছিলাম appointment letter তো দেখছি মিক্স করে
And whether the petitioner's case was considered by the principal secretary along with other matters.
No, my lord. In your the order.
Yes, yes. That is what I want from you. Now, whether the order of Saurabh Noskar is annexed to this writ petition.
No, no, Saurabh Notkar is not annexed, my lord. This is the order of.
আচ্ছা সৌরভ নস্করে কালকে যেটা দিলাম দেখো তো সৌরভ নস্কর ইয়ে করার ওই তো সৌরভ নস্কর দিচ্ছে
20,652
এটা এটা সবকটাতে একটা করে কপি রাখবে হ্যাঁ রিটেন করবে সৌরভ নস্কর
সৌরভ নস্কর এবার দেখো 20,652 নাম্বারটা লিখে দিন না তাও তোমার নাম্বারটা লিখে দিন
20652 of 23. Oh, these.
জেরক্স করতে পারো কস্ট টাইটেল গুলো আলাদা করতে
শেষ করি তো আমি 7ই ফেব্রুয়ারি।
Now in all matters date of appointment will be required. আচ্ছা এসো শুভেন্দু
লিস্ট করে দিয়ে একটা কাগজে
শোনো, এই অবধি পুরো ক্রস, এটা কাটা হয়ে গেল এই জায়গাটা। পিটিশনার করে দিচ্ছি হিজ হারের কমপ্লিকেশন হয়, এই ডেটটা লাগছে না, ডেট শুধু লাগবে এইটা। In this matter, 24th November 2023 is the date of appointment.
24th November 2020.
এটা যা আছে তাই, এইখানে নাম্বার 15টা কাটছে, পিটিশন আছে, ইজটা হচ্ছে না, বুঝলে না? আর প্রত্যেকটা সৌরভ নস্কর রিটেন রেকর্ডিং। ইয়েস, ডিসপোজড অফ। অ্যাফিডেভিট সার্ভিসটা উপরে করে দেবো, অ্যাফিডেভিট সার্ভিসটা অ্যাড করে দেবো, মনে হয় নেই, অ্যাফিডেভিট সার্ভিসটা অ্যাড করে দেবো।
আমি দিয়েছি।
এই অর্ডারটা আমি কাছে রাখছি, প্রত্যেকটাতে ফলো করে দেবো। সব ঢুকিয়ে দাও।
হয়ে গেল একসাথে? না না হয় না।
এটা
number?
Date of appointment is December 26, 2020.
শুভেন্দু, অনলি ডেট অফ অ্যাপয়েন্টমেন্টটা চেঞ্জ হতে যাবে, তো আমি ডেট অফ অ্যাপয়েন্টমেন্টে ফার্স্ট পেজের উপরে প্রোফর্মা পেজে এইখানে নাকি লাস্ট পেজে দেখে
একটু অ্যাপিয়ারেন্স গুলো দেবে।
সেইটা দেখে শুধু ওইটাই চেঞ্জ হয়ে গেছে, একটা দুটো এখানে তাহলে লাস্ট পেজে
ডেটের হয়তো চেঞ্জ হতে পারে।
লিখে দিচ্ছি।
একবার বলে দিচ্ছি।
ইয়েস, ডেট অফ অ্যাপয়েন্টমেন্ট
December, this is item 12.
12,
December 26, 2023.
26 December 2023. Now, I think all of you understand that why annexed order will not help.
Yes. No, no, not now. I have understood at that point of time. সবগুলো।
ওর কাছে আছে কিন্তু না, প্রত্যেকটা
26 December 2023. 12. Yes, disposed of. Affidavit service. Next.
item number 13.
So that 25 writ petitioners minus 1, other 24.
Other lots, there were more. I think I'm not filed it. তিনটা মামলা ছিল কি?
This is the
যেটা সবাই একসাথে ছিল।
Yes. I don't know, file your affidavit service.
11th of January 2020.
Now, in which paragraph you are indicating the date of appointment? I think that will be same in all the matters.
মানে অ্যাপয়েন্টমেন্ট লেটার have been annexed.
No, I'm just saying. Paragraph 10.
Yes. So far, item number 13 is concerned, that is 11 January 2024. Disposed of. Affidavit of service disposed of. Next. Enter your appearances.
Yes. In all
For the commission.
all the both.
In all the matters, both of you are appearing for the commission.
Item number 14.
24th November 2020.
24th November 2023. Must be in paragraph 10.
No, no.
Find it out.
Paragraph 11.
Yes.
Yes. তুমি একবারে অ্যাপয়েন্টমেন্ট ডেট গুলো লিখতে ইয়েস নেক্সট
করছো এটা ধরো
14 state.
Item number 15.
নাম দাও
11th of January 2024.
নাম for the state.
11th January
2024.
disposed of.
Item number 16. August 2024.
Affidavit of service file in all matters. Yes. August 20th August
2024.
হ্যাঁ অ্যাপয়েন্টমেন্ট লেটারটা দেখতে পাবেন এটা 25 টাকা দেখো
disposed of.
State. 16 state.
নেই
মোহাম্মদ কামরুজ্জামান
Item number 17.
Lord, I am for the state, my lord.
December 8, 2023.
State.
8 December 2023. All are 2023 appointees.
2023 or 2024. 3 or 2024.
8 December 2023 disposed of. A grateful one.
Okay. Service tax.
Item number 18.
19, 2024.
19th March
Evidence.
2024. Disposed of.
Service tax.
Item number 19.
11th of January 2024.
11
11th January 2024. Disposed of.
Service tax.
Item number 20.
December 26, 2023.
2020.
December
26.
Item 20.
2023.
2023.
Disposed of.
Service tax.
Item number 21.
Item number 21. 26 December 2023.
26 December 2023. Disposed of.
Service tax.
Item number 22.
December 8, 2020.
In none of the matters, issue was directly considered by the principal secretary. As it was done in 23rd of July 2024 order in connection with similarly circumstanced other candidates. 8 December 2023 is disposed of.
This matter, the first matter that your lordship directed the principal secretary, in that matter, notice was issued to that petitioner as well as that petitioner's requested to intimate all them. All of them went to the office of the principal secretary, but they were told that since the matter is pending, no decision or no hearing will be.
Item number 23.
December
While, yes.
9 December 2023. Paragraph 11. Eight, লেখা।
9 December 2020, item number 23.
Yes.
Item number 23, my lord.
9 December.
Yes. Paragraph 11.
Find it out.
Nandini Das. Nandini Das, 192.
8, 8, 12,
কোনটা এটা?
December 8, 2020.
নন্দিনী এই দেখ এখানে লিখেছিস 9/12
প্যারাগ্রাফ 11 এর
Join.
9/12
Join 9 baro, letter of appointment.
8/12 Join 8/12
হ্যাঁ 8 বারোই তো।
I am not saying letter of appointment. I am saying date of joining.
Joining.
My lord, I have said, I have understood letter of appointment.
Join যা বারবার বললি join when join
In terms of the said appointment letter, petitioner joined the post of assistant teacher on so and so day.
সবগুলোই কারেকশন
Well, then I am giving on all the matters, I am giving the letter of
By making a list.
joining in a specific.
একটা লিস্ট করে দিয়ে
No, আবার ডাকো।
দিস ম্যাডাম
Yes, let it be correct, rightly done. 9 December.
9 ডিসেম্বর প্যারাগ্রাফ 11
ডাকো আবার ডাকো।
11
10 12 জয়েন্ট বলছে
153
Item number 11.
না, না।
WPA 192 of 2025 order passed finally.
ইয়েস
এটাকে করে দাও, এটা ঠিক আছে, বুঝতে পেরেছো? Yes, call from item number 11. Yes, date of joining.
23 এটা 23
এখন রাখুন ডাকবো আবার।
আবার
হয়ে গেল।
হয়ে গেল তো এটা ঠিক হয়ে গেল
Item number 7.
Just a minute, item number 11.
11
এটা ফার্স্ট ম্যাটার।
আবার প্রথম ক্লাস
কিন্তু এখানে অর্ডার পাস করা হয়ে গেছে না একটা, মানে তোমার কি বলে ফার্স্ট অর্ডার তো এটাতেই করলাম। Yes, tell me.
My lord, November 28, 2023.
28 November 2023. এই ফার্স্ট 28 November 2023 11. Yes, then item number 10.
27 December.
Just a minute. 27 December. Yes. Correction করে নাও শুভেন্দু। Item number 13.
June 2024.
But appointment letter was 11 January 2024. 7
Of June.
2024.
No,
Yes.
matter was
Yes. Item number 14.
my lord 28 November 2023.
28 November 2023. Item number 15.
পিটিশনটা দেখি তো একটু কিসের আইটেম নাম্বার ওই চিন্ময় এই পিটিশনটা কোথায় গেল প্যারাগ্রাফ 10
I think this is your petition wrongly given. Yes.
কি দেখি
my lord this is
অ্যাপয়েন্টমেন্ট লেটার
15 January 2024.
2023, 2024.
15 জানুয়ারি
Item number 16.
November 28, 2023.
November 2023. 2023.
Yes.
But the appointment letter was written 20th August 2024.
No, appointment letter my lord 24th of November 2023.
This is WPA 160 of 2025.
158 my lord.
To
কি বলছে তো 15 এটা অলোকেশ
Item number 14.
গুলিয়ে গেছে
this is WPA 160 of 2025.
এইটা দেখে
Item number 60.
60
Petitioner joined on 21st of August 2024.
Yes.
হয়েছে মিলেছে প্লিজ দেখি বার করুন
21st August 2024.
তবে মোহাম্মদ কামরুজ্জামান
তারপর মোহাম্মদ কামরুল
Item number 17.
joined the school on December 13, 2023.
13 December 2023. This is 165 of 2025.
165 of 20.
তারপরে হচ্ছে কি অসীম অসীম কুমার হালদার, হ্যাঁ ঠিক 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 বলছি।
Item number 18.
March 20, 2024.
হ্যাঁ 20th March 2024 ঠিক আছে
20th March 2024. 172.
170
Yes.
দুই পায়ম
তারপরে 2 পয়েন্ট ঠিক আছে
175
Item number 19.
16th of January 2024.
হুম
175.
175 179 মাসিদুর রহমান
Item number 20.
রহমান
My lord, it is on 29th of December 2023.
179.
Item number 21.
অনুপ হালদার
It is, my lord, on 28th of December 2023. 28.
Yes. 186.
6 তারপর 187 ঠিক
Item number 22.
Yes. Now tell me.
This is new.
Yes. Date of appointment.
My lord, date of joining, my lord.
That is the date of appointment, not appointment letter.
Yes, ma'am.
Yes, date of joining.
is December 12, 2023.
Right. 12 December
12 December.
22
Disposed of.
তারপরে নন্দিতা দাস দেখুন নামটা দেখুন নন্দিতা দাস ঠিক আছে
Nandita Dam.
Item number 23.
It is already disposed of. 23, my lord. The
Corrected,
matter has been
already corrected না
Yes, yes. yes. 9 December.
yes হয়ে গেছে okay 24 এই মন
Item number 24.
নন্দিতা রয় 28 December
My lord, this is on 28th of December 2023.
28
28 December 2023. Disposed of affidavit service.
24 তবে স্বপন সেন
Item number 25.
Yes.
My lord, January 16, 2024.
Disposed of.
Item number 26.
রেশমা 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 দেখে নাও
My lord, June 22, 2024.
2024.
June
Disposed of.
Item number 27.
December 28, 2023.
28 December
28
2023.
2023.
Disposed of.
I am appearing for this.
ঠিক আছে
Item number 28.
হ্যাঁ তনুময়
Here for the state. My lord.
তনুময়
Yes, date of appointment.
December 29, 2023.
29 December
Disposed of.
তারপরে আব্দুল মাহবুব দেখে নাম লিখে
Item number 29.
December 2023.
My lord, I'm for the state resolutions.
16 December 2023.
My lord.
Disposed of.
দত্ত ঠিক আছে রবি দত্ত
Item number 30.
January 17, 2023.
ঠিক আছে
17 January
Yes,
17.
2024. Disposed of. You have stated this in either paragraph 10 or 11.
11.
Item number 31.
15th of January 2024.
Disposed of.
কত পর্যন্ত? 36.
Item number 32.
27th of December 2020.
27 December 2023. Disposed of.
Item number 33.
28, 2023.
28 December 2023. 28 December. Disposed of.
নাম দিয়ে দিচ্ছি। হ্যাঁ।
Where is your partner? So far the commission is concerned.
Since I am here, my lord.
Item number 34.
This is item number 34.
34.
Yes. December 34.
My lord, December 13, 2024.
13 December 20.
Yes.
Item number 35.
I am appealing for commission.
Item number 35, I was requested your lordship to take 36, then 35, because 35 should be taken, but they have petitioner hearing and instructed me to challenge something more than notional benefit. He wants, according to rules, your lordship knows, he wants that he should be given an opportunity for counseling, because the rule says at that point of time, 11th, at the time of 12th RLST, that after personality test, a person should be called for counseling so that according to merit, he may get to choose a school. He says that my merit should be considered and my merit should be positioned in the merit list and I should be given a chance for counseling, because now I have been posted some 200 kilometers from my residence. If I am entitled to get a school nearer, why will I not? This will be decided with affidavits, my lord, subject to correction. This is my specific instruction in this matter. I have prayed for that.
এইটা 35
36 বললি না?
না 36
What is the date of appointment?
Date of appointment. Date of appointment is 20 August 2024.
20 August
2024. He has not joined.
Oh, he has not joined.
Not joined because he previously also he filed this writ petition, my lord. It was withdrawn. It was filed jointly, my lord. He has again filed this petition that I should be given a chance for counsel.
If he has not joined, then the question of considering now all of a sudden that is not possible. I'll have to take instruction.
I have filed the writ petition well immediately after.
Then what happened to that writ petition?
My lord, it was withdrawn with liberty to file
afresh. So you obtain instruction.
Yes.
Because yes, he is saying that the candidate who has been recommended, he should be given opportunity to choose the post as per the availability of vacancies.
Yes.
That counseling was not done. The petitioner is not at fault. There was a re-evaluation, and on re-evaluation, petitioner came within the zone of consideration.
Yes, I'll take instruction, and if necessary, I'll come back with a report.
Issue. Affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Petitioner participated in 12th RLST 2011 or 12th Regional Level Selection Test 2011. But contemporaneously, he was not selected for being appointed in the post of assistant teacher. Stop. However, subsequently, in 2023-2024, petitioner was found to be eligible to be appointed in the post of assistant teacher in connection with the selection process of 2012 on re-evaluation of answer script. On re-evaluation of answer script. Stop. Petitioner has been recommended. Stop.
And appointment letter has also.
Petitioner has been recommended by the concerned authority of the West Bengal Central School Service Commission for being appointed, and to that extent an appointment letter was issued. But petitioner refused to join the recommended post on the plea that he should be given opportunity to participate in counseling in order to opt for a post from available vacancies. Stop. Next paragraph, Dr. Patro, learned advocate representing the commission, has prayed for accommodation to obtain instruction. Next paragraph. The learned advocate, the concerned authority of the commission is directed to file a report in the form of affidavit by 2 weeks from date. With an advance copy upon the learned advocate representing the petitioner. Next paragraph lists the matter under the heading motion on 26th February 2025.
No, then may I have 3 weeks?
Very good.
Easy adjust.
Yes, 3 weeks. What are 2 weeks to 3 weeks?
If you obliged.
Item number 36.
Same. 28th December.
Same thing. You are praying for counseling.
No. Motion. December 28th, 2022.
Sorry.
20 December 2023. Same order.
Only one thing, my lord.
Average service. Yes, give your appearance.
Item number 34, my lord. It should be 2023. I have told the lordship's officer it should be 2023. Probably your lordship has recorded 2024. I said 2024, but it should be 2024.
Without a minute, item number 34.
34.
WPA 225.
Please kindly come to me.
Just a minute. Let the record be placed. Yes.
Page 28. If your lordship.
13 December 2023.
My lord, page 28, because my lord, in paragraph 11, my mistake, it was written as 2024, but I have annexed the joining report, my lord, it says.
Hey, শুনুন যেটা ফার্স্ট ম্যাটার এটা রাতে এই দিন কিছু করতে হবে এটা নিয়ে নাও মানে কি করে করবি আর সৌরভ নস্করটা ওইটাতে রিটেন করতে হবে প্রত্যেকটাতে একটা করে এটা নিয়ে এটা নো আদার সিমিলার ম্যাটার্স হ্যাঁ জেরক্স করতে পারে Yes. Item number 37.
For the state.
Hey, just a minute. Yes. একবারে ওটা হয়ে গেলে ওটাকে নিয়ে চলে গিয়ে দুজনে বসে সব অর্ডার পাস ওটা 26 PPF to GPF এরিয়ার পেনশন
25 কপি জেরক্স করতে পাঠিয়েছি তোমার ওখানে ঢুকে
31st March 2007 superannuated assistant teacher.
Date of appointment, the date of
এটা আবার কি? 230 pension payment order dated 26 May 2015 to Giras. প্রত্যেকটা মানে কিছু এখান থেকে even এটা এই 35 ছাড়া 11 থেকে 36 সবকটা ফাইল অর্ডার এই দুটো অর্ডার ক্লিয়ারের সব সেটাই তো ক্লিয়ারের কথা হলো 16 মাস এটা এই সাইডে 300 নয় ক্লিয়ারের 600 ভাগ এটা তাহলে দেখা দেওয়া দরকার না যেটা ক্লিয়ারের 600 ভাগ এটা দেওয়া দরকার 2600 ভাগ জেরক্সটা এসে একবার ঢুকিয়ে দিই জেরক্সটা আছে এই ফাইলগুলো নিয়ে নে। বললাম বলছে পরে ঢুকিয়ে দিলাম এখন পাঠিয়ে দাও এই শোনো এটা করে দেবে আর পেনশন সিপিএফ জিপি হ্যাঁ কিন্তু এইখানে না এই হিস আর এসব আছে Correct?
অ্যাফার্ম হয়ে গেছে, রিঅ্যাফার্ম করতে হবে।
I will grant leave. Affidavit service filed on behalf of the petitioner is taken on record. Leave is granted to the learned advocate representing single petitioner.
No,
No,
there are
petitioners court.
petitions.
On behalf of the petitioner, leave is granted to the learned advocate representing the petitioners to amend the first page of the affidavit of service and indicate correct year of the writ petition. Stop. You have indicated wrong year of the writ petition. It has been stated 2024. It should be 2025. Next paragraph. Petitioners participated in 7th state level selection test within bracket assistant teacher hyphen then hyphen এটা দেখবে then hyphen TET এই hyphen TET 2023 for class 5 to class 8. Stop. Petitioners have raised grievance that in spite of relevant guideline of National Council for Teacher Education not permitting negative marking in TET, but West Bengal Madrasa Service Commission indicated in their information guidelines for 7th SLST within bracket 80 close bracket 2023, as well as in question booklet that there would be negative marking for answering wrong for giving wrong answers. Stop. However, subsequently, the defect which cropped up was attempted to be cured with a notice dated 24th December 2024 informing all concerned that there would not be no negative marking. Stop. Learned advocate representing the petitioners has relied upon the order passed by this court in similar circumstances on 14 January 2025, passed in WPA 688 of 2025, within bracket Mohammad Nurul Hassan Mondol and others versus the state of West Bengal and others. West Bengal and others. Stop. Next paragraph. West Bengal Madrasa Service Commission is represented. Madrasa Service Commission and the state are represented by learned advocates. Next paragraph. On perusal of the order dated 14 January 2025, passed in Mohammad Nurul Hassan Mondol Supra, it appears that the order passed. Passed on 14 January 2025 shall cover. The order dated 14 January 2025 covers the issue involved in this writ petition. Next paragraph. Let order passed in Mohammad Nurul Hassan Mondol Supra be retained with the record. Next paragraph. Next এই দেখো এইটাকে সেট আউট করে দাও, সেট আউট করবে না মানে এটা লিখে দেবে তারপরে Same order.
Lordship,
That, but the result shall not be published without leave of this court, direction for affidavit.
This matter also we file affidavit. This
Yes,
matter.
But separate petitions are not required to be moved.
I have filed.
Because already, yes.
They are there.
In the morning, similar petition you mentioned
This
before
one,
this
this
court. Yes. Item number 45. You are for the school.
But I am for the second school.
Yes.
Third school.
Yes, yes, yes.
My son, admitted in the Sorisha Ramakrishna Mission. Now, kindly come to page 15. That from that school, on 8 September 2024, transfer certificate issued. Next page, from that school, Dostapur High School, he admitted. Now,
Dostapur High School.
Now, initially, that in the Ramakrishna Mission School, his name of my son was the registered in the before the board. Now, only the transfer.
Your name was registered
from that school
in connection with Sorisha Ramakrishna.
Sorisha.
Yes.
Now, after the transfer, I first took admission on Dostapur High School. Now,
In which you took admission in the second school in which year? In which class?
Class 10, na? Class 10. Now in the second school, I have also the transfer taken. Now,
Now you want correction of your registration certificate
Registration
incorporating name of the present school.
present school. Since this is my specific case, kindly comes to the
Registration certificate.
No, there is no registration issued, Malal.
no, kindly comes to page paragraph 15. In brief, my case. Mr. Bhattacharya's client,
Just a minute.
Page 15.
No, paragraph 15. Page 8.
But this is not the second school. It is
No,
Kopat
third school.
Khada school.
Third school. At present school,
First Sorisha, then Dostapur, then Kopat Khada.
Yes. Now, I am at Kopat.
In class 9 and
Now 10, I am the for the Madhyamik Parikha,
Just a minute.
25.
Now, first you are a student of first school. Then in the first school, in class 9, you took transfer, or in class 10?
Yes.
In which class you took transfer from first school to second school?
My class 10.
Class 10. Then in from second school to third school? Again in 10. Why?
In the second school, the duration was not the.
So why you had to take two transfers?
That is nearer to his residence. That is. Page paragraph 13, I have stated.
During such a short span, why you had to take transfer so frequently?
That is that school is nearer to his the residence.
Are you an exceptional student?
But he unsuccessful in class 9. I have the mark.
In Sorisha Ramakrishna Mission.
Well, their rule says that if not successful in class 9, he cannot be admitted in class 10 and cannot appear in month. So, only to evade.
Then to evade this, he took admission in the second school, Dostapur.
Yes. And thereafter, from there to another school.
So what is the reason for taking, you are representing third school. So what is the reason for taking transfer from the second school?
But that reason I don't know. But it is
But why you have permitted admission in class 10?
But that is the fault
that is not permissible.
That is the fault
that is not permissible. In class 10, admission is not permissible.
Not only that, your lordship, Dostapur, the transfer date of transfer is 5/2/2024, and that his school took admission date of admission in the month of January prior to issuance of the transfer certificate from Gostapur. The Khadwa school.
Kapat Khondo, yes.
Yes.
Kapat Khondo.
No, my lord, kindly see page 6.
Now, what is the stand of the board? After
If a candidate is not successful in class 9, there is no school.
then what?
He will have admission in class 9. He will have to pass class 9, get promotion to class 10, and thereafter appear in the exam. Because rules provide you, Lordship. I have the rules.
Show me the rules. Examination rules. You cannot avoid in this. First,
Yes, my lord.
in order to take admission in class 10, you change the first school and took transfer, join the second school.
And
Then when you found that no registration is not complete, file a writ petition.
Now, my lord, kindly.
Yes,
When he
yes.
was in first school, he applied for registration.
Yes, show me the.
This is rule 17. May I read?
Now,
No,
kindly.
give me the rules.
Before that, kindly come to page 13. What happens to the another 13 students? Similarly, circumstances.
One wrong cannot be perpetrated by another wrong.
The petitioner approached the present school.
Rule 17B and
The present school permitted the son of the petitioner.
Examination rules.
done it wrongly, cannot do it without permission of the board.
During the examination, he must be eligible to be. কোনটা দেখাচ্ছি দিদি?
Rule 17.
ওইটা এনেছো?
Rule 17.
Oh, class 9 pass করতে হবে।
জানি আমি। আরে ভুলটা তো আমার কাছে করেছে।
ওখানে সানসেস সার্টিফিকেট
So, rule 7, eligibility of regular candidates to appear in the examination is he has to, the petitioner has to pass class 9 and class 9 annual examination and class 10 test examination. Show me that you have passed class 9. Then I will give it.
Now, that is admitted. That is
So, if that is admitted,
kindly comes to page 33. Kindly comes to page 30. Board cannot discriminate these persons. They are also my classmates. That branch admitted in that school. Kindly comes to. They are also
all failed candidates took admission in Kapat Khondo.
Yes.
Then school is
How you permitted to?
all those students are from Kapat Khondo, all the students from Shodisha.
Yes.
Shodisha. So when a school is elected, school produce, all of them are unsuccessful or not.
If similarly circumstance, other students who were reading in studying in class 9 in the first school, that is Shodisha, if they took if they were permitted to take transfer and take admission in Kapat Khondo, and if their registration is done, then why petitioner will be left out?
That is
I will answer to this.
When the students are in class 9 in Shodisha, all of them applied in class 9 for registration. So, this particular student, Your Lordship, what he did, he prior to his registration was done from that Shodisha, he made another application for registration in class 10 from this Kapat Khondo.
Okay.
So, both the registration application of the student is before the. So, our student must apply.
So, so far petitioner is concerned.
Yes.
Petitioner filed, made 2 applications for
Yes,
registration.
one
One from.
So both applications, I have the copy of the applications.
Then,
our student can apply from both the schools. So now it came to the knowledge there is a lot of mistakes on part of the.
but in case of other students, they applied for registration from Kapat Khondo.
No, I don't think that I have to let them produce from where they have taken the registration. The school is here.
Yes, in paragraph 30, I have stated, I have annexed the registration certificate. registration certificate annexed at page 30.
Page 30.
সিজিটিতে দেখুন যেগুলো এসেছে তাদেরকে ওখান থেকে এসেছে তাদেরকে ইস্যু করেছে
No, how you can cross the hurdle of the examination rule?
Well, if something is done wrongly, my lord.
Yes, that cannot, there is no question of negative equality.
But my lord, no, my lord, at the time of admission, my lord, the
and if court passes this order, then this practice gets encouraged.
Lordship, it will open a floodgate.
Cancel their registration also. Otherwise, this petitioner.
That is not the issue in this writ petition. Have you prayed for their cancellation?
No, I am not
then
prayed for.
Why court will do this?
Kindly comes to page 30.
These people are not party before your lordship. On basis of whom He is asking for an order from a lordship.
But
And
the
they
school-
got registration from Kopat Kondo, that is in class 9. They must have taken admission in class 9 in Kopat Kondo.
No.
Because the board never allows any registration application in class 10. All registration application must be done in class 9. Then let all of them be into a party and now
এটা তো ক্লাস 9 এ পেয়েছে
এটা class 9 এ পেয়েছে, হ্যাঁ। Because all of them took admission in class 9.
You give copies of 2 applications made from 2 different schools for registration.
And this is for Shorisha Ramakrishna and this is from
Hand over, yes, file it.
Kindly comes to page 16 and page 27.
আলাদা
But how your Kopat Kondo high application can be entertained? Because for admission of Madhyamik Pariksha Secondary Education 2025, application form for registration of student of class 9 2023 in connection with Kopat Kondo.
No.
But in 2023, you are not reading in Kopat Kondo.
and your lordship the instance
Esho.
Kindly comes to before passing on, kindly comes to page 16 and page 27 and 28. Page 16 relates to the son of the petitioner. Last class passed, class 8. Last class attended, class 9 academic.
Page 20?
Page 16.
Yes.
1-6. The bottom portion, last class passed 8. And the last attended, class 9 academic session 2024. Now kindly comes to page 27. My learned senior friend is submitting that is their registration in class 9. Now 27 name of the student is Sayan Ghosh. Now in the bottom portion last
He is
class,
the petitioner's son.
no petitioner's son page 16. The another student. Transfer certificate issued from the Odisha, class 8 passed and class 9 academic session 2024. Now the next page, the board issued the registration
Transfer certificate. What is the name of the school?
Name of the school on the top. Odisha Ramakrishna Mission Shiksha Mandir HS.
Yes.
Now page 15, page 15. Page 15, page 16 the next. Page 15, the petitioner's son. Odisha Ramakrishna Mission Shiksha Mandir.
Page 15.
1-5. What the student's name is? Sonnayu Pramani. One of the class 8 pass, last attendance class 9 academic session 2024. Now kindly comes to page 27. Student name is Sayan Ghosh. That is also from Odisha. Now the bottom portion, last class pass 8, class 9 academic session.
Page 27.
Page 27.
Yes.
The same batch. Now the next 28 board is issuing registration certificate in respect of Sayan Ghosh, class 9.
Page
28.
28.
Yes.
Yes.
Both the students transfer from the Odisha Same.
Show me that in case of Cyan Ghost, 2 applications were made for registration.
One more thing, your lordship.
Please. Otherwise, there will be it will not end. Yes. Show me that 2 application registration certificate registration application was made.
That present school can the
Yes, yes. Issue.
But before your lordship passes an order, but only it's a request. Can this be solved?
No.
The carry.
No, then what
the
fault other candidates have done?
But
Those who could not make attempt to participate in the examination being failed in class 9 in 2024.
But I tell your lordship, total 13 students are there.
Because
11
there are judgments that failed candidate in test examination has no
But
right.
I will not go into this.
Similarly, failed candidate in class 9 has no right.
But out of 13 students, 11 problem has been solved. Only 2 are left. So, but if your lordship kindly show some mercy, only this much, nothing else.
Class 9 was not successful, your lordship. We don't know about other students. Then let them make the other students party and let me get all their documents. Because my lord, here we find, my lord, in this particular case, your lordship, the Dadupur, Dostapur gave a transfer certificate on 5th February 2024. And for Kapakstaga, from where he filed the another registration certificate, finding your lordship, the date of admission is the month of January, prior to issuance of the transfer certificate. It is there, your lordship, kindly find that Kapakstaga registration form. The last portion, right side.
No, this practice I deprecate. Changing school in class 9 and 10 repeatedly in order to avoid the result wherein he was declared failed candidate in class 9.
That is, I will not stand.
I deprecate this practice.
I will not stand in that.
And also the stand of the guardian. This candidate should have been asked by his guardian to
sit for the
study
examination
in class 9 in Sorisha Ramakrishna Mission school.
But apart from all these things, but can something be done?
His guardian should have asked him, you read for the next year in the same school and qualify class 9 examination and take and come and be promoted to class 10. Everything cannot be done by filing writ petition before the High Court.
But it's a prayer, but it's a prayer. The fate of a student, but it's a prayer. If your lordship kindly, all of us are here, Malad, if the problem can be solved. Out of 13, 11 got the fruit of this. Acting same school. But if something be done,
the father of the petitioner has approached this court, inter alia, praying for issuance of transfer certificate.
The registration certificate.
Issuance of inter alia, praying for issuance of registration certificate on completion of formalities by the West Bengal Board of Secondary Education, within bracket hereinafter referred to as board, close bracket board, quote unquote, which would facilitate the petition, petitioner's ward to participate in the ensuing Madhyamik examination 2025. Stop. Learned advocate representing the petitioner submits that the student, representing petitioner submits that his son was student of Sorisha Ramakrishna Mission Shiksha Mandir South 24 Parganas of class 9 in 2023. You are student of. Yes,
23 in
please
class 9.
hear the dictation. 23 in 2023, but he could not qualify. But he could not pass class 9 annual examination and subsequently took admission in class 10 in Dostapur High School, South 24 Parganas. Stop. Subsequently, petitioner took admission in class 10.
The petitioner's son.
Subsequently, the student took admission in class 10 in Kopatkhand High School within bracket HS
Prior to issuance of transfer certificate by the previous school.
within bracket HS in 2024 in class 10. Stop. It is contended that being the student of class 10 in Kopatkhand High School within bracket HS, application was made for issuance of registration certificate in order to permit the student to participate in Madhyamik examination 2025. Stop. Second limb of submission on behalf of the petitioner is similarly circumstanced other students in Kopatkhand High School within bracket HS have been issued transfer certificate. Therefore, non-issuance of another limb of second limb of on behalf of the student code or on behalf of the petitioner is
circumstance other.
পড়ো না petitioner থাক
Mainly the legal submission of the petitioner. There is circumstance other in
Kopatkhand High School within bracket HS
issued transfer certificate.
and therefore if petitioner is denied registration certificate, that would amount to gross discrimination. Stop. Petitioner prays for direction upon the board to issue transfer certificate in favor of his son. Next paragraph. Board and Kopatkhand High School within bracket HS are represented by learned advocates. Stop.
Odisha is also.
Lord, I represent Ramakrishna.
Board, Kopatkhand High School and Sorisha Ramakrishna Mission, Shiksha Mandir are represented by learned advocates. Stop. Next, on behalf of the board, it has been submitted. Since the student did not pass class 9 annual examination conducted by Sorisha Ramakrishna Mission Shiksha Mandir in 2023, he cannot participate in 2025, cannot participate in Madhyamik examination 2025 since same is prohibited under Rule 17. Under regulation 17 of West Bengal Board of Secondary Education within bracket examination close bracket regulations, 2001. Stop. It is also submitted that in a short span of time, petitioner took transfer first from Sorisha Ramakrishna Mission Shiksha Mandir within bracket HS and subsequently from Dostapur High School, and ultimately took admission in class 10 in Kopatkhando High School within bracket HS. Copies of 2 transfer applications petitioner বললাম দেখো তুই অ্যাডমিশনটা
ultimately to the
না তার আগে
short time of time. It is also something that a short span of time. Petitioner took transfer.
and a student.
Student took transfer first from such and such and subsequently from the school and ultimately took admission. Last year,
Dostapur High School.
Copies of 2 transfer.
Copies of 2 transfer applications. Now, copies of 2 applications for issuance of registration certificate are placed before this court on behalf of the board and same are taken on record. It appears from 2 separate applications that first the student made application for registration being the student of Sorisha Ramakrishna Mission Vidya Mandir in 2023, and subsequently in 2024 another application was made for registration being student of class 10 of Kopatkhando High School within bracket HS. Stop. Sum and substance of the submission made on behalf of the board is, in order to defy the result of annual examination conducted by Sorisha Ramakrishna Mission Shiksha Mandir, the student took admission subsequently in 2 different schools and has made an attempt to get registration from the board by making application being the student of class 10 in Kopatkhando High School within bracket HS. So, next paragraph. Having considered the submissions made on behalf of the parties and taking note of the taking note of 2 different applications, one made in 2023 and another made in 2024 from 2 different schools seeking registration, it transpires that a student followed wrong path in order to evade টা কেটে দাও, in order to eschew the result of class 9, eschew the annual result of class 9 annual examination, wherein he was declared not qualified. Stop. It has been specifically provided in rule 17 within bracket C of the regulation of the examination regulations of 2001, that the candidate has to pass annual examination at the end of class 9 to become eligible to participate as regular candidate in madhyamik examination. Regulation 17 within bracket C is reproduced below. এটা reproduce করে দেবো, হ্যাঁ? Stop. এইটাকে হেডিংটা দেবে 17 দিয়ে, এই হেডিংটা দেবে বোল্ড যেটা, দিয়ে তারপরে দিয়ে ডট 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 রেগুলেশন স্টপ, ঠিক আছে, স্টপ. In the test examination in your school, he has been declared successful.
Yes. Yes. হয়ে গেছে, টেস্ট হয়ে গেছে।
Next paragraph.
Right, naturally, Lordship, the school have taken admission of these fake students. Now, from here, I understand 16 years saying, though I don't have the knowledge. So this school must be at stake, Your Lordship. The conduct of the school is very bad. There must be an order passed. My Lord, I submit before Your Lordship, receive before Your Lordship, an action to be taken against the head of the institution of the school.
Because if the admission would have been denied by the school authority, then this situation would not have cropped up.
He submits that there are 16 students. So, my Lord, he is in habit of doing all these things, which is totally illegal. Without permission of board, they cannot take admission in
not in my school. 2 students came to my school.
Then तुझे 16 बोलले, ओदे स्कूले 16.
हाँ.
Oh.
2 students came to my school.
Kopatkhando, there are 2 students.
2 students.
What happened to another student?
Same thing.
No. Another student, the next matter, my Lord, that student took transfer in class 9.
No, it's a different matter.
My case 13 students from
Not in this school. Stop. তুমি ঝামেলা করছো, এটা অন্য স্কুল। Stop.
মধ্যমগ্রাম স্কুল।
ওটা অন্য স্কুল, বর্ধমান। এটা অন্য।
It has also been argued that similarly circumstanced other students have been permitted to get registration, have been permitted to complete their formalities relating to registration for participating in madhyamik examination 2025 but that ought not improve the present case. Stop. If wrongly any other candidate, if wrongly any candidate is permitted to obtain registration certificate, that does not confer right upon the petitioner to get registration certificate, which is not permissible in accordance with law. Stop.
They are not party people, your lordship.
In the present case, issuance of registration certificate in favor of other candidates excepting petitioner is not an issue. Stop. Next paragraph. Therefore, the prayer of the petitioner to issue registration certificate stands refused. Stop. Petitioner stands refused. Stop. The student shall be permitted to study in class 10 for another year, but he has
Class 9. You have to read in class 9, get promotion to class 10, and in class 9, he will have to apply for registration. This is for his own fault.
No, that is not my.
Because unless
but there will be a sacrifice of 2 years in that.
Yes, lordship, in class 10, there is no option of for issuing registration certificate or applying for registration certificate. The rule is very clear.
When your class 9 examination will come in, will be held. Yes.
But then I have to take instruction on this. I don't.
Annual examination কখন হয়? December মাসে?
December. January to December.
ডিসেম্বর তাহলে এবারে পারমিট এবারে বসে বলি তাহলে নাই
সে তুমি বলো আমি অ্যালাউ করে দিচ্ছি
then to save that year kindly since they have also some mistake kindly permit the
তুমি মকরা থেকে ইনস্ট্রাকশন
Yes, kindly permit the yes.
the student to sit the class 9 examination, final examination. Then if I complete that, then no problem regarding the issuance of registration certificate.
He is studying in class 10. Can he compete in 9? পারবে?
I will direct the school to hold a special examination.
I will.
For the student in the month of February 2025, because you have to prepare for you have to prepare yourself to participate in class 9 examination. কি বললেন?
So in the present case, registration of issuance of registration certificate in favor of other candidates except the petitioner is not an issue. To stop. Therefore, the prayer of the petitioner to issue registration certificate stands refused. So the students shall be permitted to
Now, in order to next paragraph, in order to get it, so that further academic year of the student may not be wasted, as a special case, school authority of Kopatkondo High School or school authority now, authority of Kopatkondo High School directed to hold a special examination which is to be treated as an annual examination of class 9 for the petitioner's son only, which is to be conducted in the month of February 2025. Stop. If petitioner qualifies such examination, if the student qualifies such examination, in that event, the student shall be permitted to prosecute studies in class 10 in the said school for the rest of the period of 2025. Stop. Fresh application shall be forwarded to the concerned authority of the board for registration of the student by the authority of Kopatkhando High School by April 2025, and on completion of formality, such application for registration in connection with the student in connection with the son of the petitioner shall be allowed.
For him to appear in Madhyamik in 2026.
Yes, shall be allowed. Thereby permitting board shall permit the student, or thereby board shall permit the petitioner's son to participate in Madhyamik Pariksha 2026.
If all other formalities are completed.
Yes, that I've said.
And at a special case, you know.
Yes, that I have also said.
No, that
Stop.
is the case of
Stop.
school.
Please don't disturb. Stop. Next paragraph. The practice found by this court as resorted to by the student in the present case with the help of his guardian to take admission in class 10 in another school, though the student was declared not qualified in class 10 examination, in class 9 annual examination in the first school, that is Shorisha Ramakrishna Mission Shiksha Mandir, is deprecated. And in spite of such, and in the event, petitioner would have been permitted to participate in Madhyamik examination 2025 in spite of aforesaid malpractices, then the student would have received further impetus to resort to such practices in future. Stop. However, the concerned authority of board is directed to issue show cause to the school authority, show cause to the authority of Kopatkhando High School within bracket HS District South 24 Parganas inviting explanation as to why the student was permitted to take admission in class 10, though he was declared as failed candidate in class 9 annual examination conducted by different school. Stop. In the event satisfactory explanation is not offered by the said school authority, board shall be at leave to take steps accordingly against the said school authority.
But your lordship, kindly, but
One more thing, madam.
Next paragraph. With the aforesaid directions and observations, the writ petition stands dismissed.
And one more thing.
Urgent xerox certificate.
One more thing, my lord. Kindly give a direction for cancellation of both the application of certificates. Otherwise, my lord, the new one will not go because the system. Which
As per court's order, this will go.
One line.
Sorry.
Two applications will
Sorry.
rejected, you want.
এটা রেখে দাও। If he passes class special examination, which is to be conducted in February 2025, then he will be permitted to prosecute studies in class 10 for the rest of the period in 2025.
the last 3 lines of the order.
No, you are the mischief maker. Your permission has resulted. Your permission has caused prejudice to the
I did
student.
not say anything. I will tell the headmaster.
Item number 46.
For the petitioner.
But I pay for the school.
At the initial year of life, if a student resorts to such practice, then what will happen so far as future is concerned?
I pay for.
He will follow the same path in future also.
Same.
Lordship, I am for the petitioner. This is a case of re-registration of Madhyamik examination 2025. The son of the petitioner took transfer in the school Modhamgram Premamoy High School HS in the year 2023. My transfer.
Failed candidate.
No.
It is in class 9.
Heat 9.
My transfer certificate in page 16, and after that it is.
Yes, where is your transfer
passed the-
certificate?
Page 16. And he passed the test examination, that is in
এই
page
বইটা রেখে
22.
দেবে কিন্তু ওটা পড়ে দিলে রেখে দেবে। Yes. Page 16.
Yes.
Same school, Sorisha Ramakrishna Mission.
Mission to Modhamgram Premamoy High School. HS.
But he passed class 9 annual examination.
From the transfer school.
So he took transfer in class 9.
And my test examination qualification.
Registration certificate issued from Shorisha, class 9. Registration certificate.
So registration was done from Sorisha.
From Shorisha.
From Sorisha, and thereafter he took transfer before participating in annual examination and took admission in which school? Modhamgram PM High School. Now, what is the difficulty?
Name of the school needs to be changed.
But I'll say what is difficult.
So you want correction of transfer certificate incorporated?
No. In the registration certificate, the name of the school needs to be corrected.
Yes, that is what I am saying.
No, not registration.
Correction of your, not transfer certificate, correction of your registration certificate incorporating name of the present school of the petitioner instead of Sorisha.
No, that is not her prayer. Her prayer is that from the new school, he has not been enrolled for appearing in Madhyamik examination. And in the portal, her name is not appearing because your lordship kindly come to page 22.
Where is the registration certificate?
Page 16.
Page
No,
15,
registration
page
certificate
15.
is transfer certificate.
14.
Page 15, page
14, 15.
So you correct the registration certificate.
Registration certificate. This is first of all, the issue is not for the correction. The issue is she is unable to sit in the Madhyamik examination of 2025. Why? Because her name has not been enrolled. Now here, the fault again the school and also the student. What the system is, when a student takes transfer, then the school who he is admitted, the school is to inform the board, take permission from the board and inform the board that such this is the student who will appear, because registration is done from another school. So when in class 9 we come to know that which students are appearing from which school, and accordingly when they fill up the we send them the names, and accordingly the online portal is there and they fill up the enrollment form for appearing. The enrollment form, the last date has gone on 7th January. They appear. So what this school did, this school never informed board or never took any permission from board that this particular student got registration from that school, but now she will appear from my school. So the school have never sent. board does not have the knowledge. Now, when board have sent the portal to fill up the enrollment form, the name of the student, this student is not appearing. So you will not find any single representation either by the school or by the.
So now what can be done to save the career of the student?
This is a fault.
But this is not a case where petitioner failed in class 9 examination. So the board has to come in aid of the student and make an arrangement.
I have taken instruction that we will. This student matter, we have.
They will come at 2. I will hear this matter first and then matters from the combined list.
But I have the representations also. You are appearing for the school. Madhumgra. Which?
Indulgence.
No. Mention tomorrow. If it is very urgent, why you are mentioning now? In other matters, I have marked you.
Oh, my lord.
Why you take this, try to take this advantage?
No advantage, my lord. Actually,
What is the urgency?
urgency is a read period. My client is more than 85 years age. He is at the stake of the at the verge of the totally bedridden. And this is a municipal matter, KMC matter. KMC has totally cheated my client.
But I don't have the determination only hearing matter. I am not,
hearing matter.
I am
my
not
lord.
including
This
any
is-
municipality
this is-
matter and hearing matter you are
this-
mentioning at 2 p.m.
No, my lord, this is my fault. I'm only just
Hearing matter you are mentioning at 2 p.m. when you have filed the writ petition.
No, that's why I'm praying for indulgence, my lord.
Why? Why? You are not new in this profession.
Yes, my lord. That's my fault, my lord.
It's a very bad habit. I am, so far you are concerned, I have marked you in, noticed you in other on other occasions too.
That is my fault, my lord. That's my fault. I shall come on Monday, my lord. I shall come on Monday. It's very urgent.
What is this?
hearing matter নিচ্ছেন না
No, hearing matter.
I am not including any hearing matters from irrespective of class, not even from group 2.
hearing matter অন্য বেঞ্চ আছে আপনি জানেন অন্য বেঞ্চে
And you are mentioning hearing matter at 2 p.m.
Sorry, my lord. I'm extremely sorry, my lord.
You should be sorry
I'm
and
extremely-
ashamed for your performance before this court.
I'm extremely sorry, my lord. Extremely sorry. I'm very much sorry.
মেজাজটা নষ্ট করে দিয়ে চলে গেল।
মেনশন করেছি হিয়ারিং ম্যাটার তার মিউনিসিপালিটি
Yes, yes, yes. Place your case.
Lordship, this is a matter of re-registration of Madhyamik examination 2025. The son of the petitioner took admission in the Madhyamgram Primary High School in the year 2023. Previously,
You were a student of
Sorisha Ramkrishna. After that, I'm a student of Madhyamgram Primary High
For
School.
participating in annual examination in Sorisha Ramkrishna Mission in class 9, you took transfer and took admission in Mudhamgram PM Girls High School. Yes.
Transfer certificate in page 16. It is, and after that, the registration certificate has been issued.
Where is your registration certificate?
Page 15. As the registration procedure done by the Sorisha Ramkrishna Mission, the name of the school written as Sorisha Ramkrishna Mission School. Now, I am the student of Madhyamgram, so the name of the Madhyamgram should be included, and my and the Madhyamgram Primary qualification.
But if pleadings are there, then this court can pass an order. There is a judgment to that extent. Even if prayer is not there, if pleadings are there, then he can.
That is
And the student
prayer is
yes, Ms. Bhattacharya.
Here, this case is different. Here, the case is he has been registered from a registration certificate from Ramkrishna. In class 9, who took transfer, there is no question of any other thing. But when she took transfer in the present school, my lord, the school authority should have informed the board asking to enroll to get the particular student name registered with the board, not registered or enrolled with the board, that this particular, along with the existing student of my school, this particular student will be appearing. For that, well, kindly come at page, there's a notification of the board. Well, kindly come at page 20.
Yes.
Well, here, one last special opening for online enrollment for Madhyamik.
Where from you are reading?
First time.
First. To head of all class, to the heads of all 10 class high schools, notification. Now, my lord, the enrollment process, normally everything is online through portal. And the enrollment process started from 9th November 2024 and continued till 19th December 2024.
Where is the indication of the
Lordship, in continuation of a previous notification dated such and such, dated at and dated 19 to 20 respectively regarding the online enrollment of eligible registered students for appearing in Madhyamik Porikha 2025, which concluded on 18/12/2024, first phase, and 3rd January 2025, second phase. It is noted that though 9281 schools have successfully completed their online enrollment process, yet some residual cases of missed enrollment are being reported to the board. Therefore, for one last time, the board has decided in the students' interest to offer a special window by keeping the enrollment portal open for registered, continuing or compartmental students who fail to complete their enrollment to their respective schools for 24 hours from 11 a.m. on 6 January 2025 until 11 a.m. 7 January 2025. This one last window is specially for the students who missed the initial deadline of 18/12/2024 and could not utilize the period ending on 3/1/2025. So, my lord, board has again opened for this type of students a portal so that they can get it enrolled. But, my lord, the school authority have not taken this opportunity. The school authority is not done.
That was the last opportunity from 6 January 2025.
Yes.
Till 7 January 2025.
This petitioner took transfer in 2023, got admitted. So, my lord, the first phase was in January. First phase 12 in December, 18 December, first phase. Second phase on 3rd January 2025. The school sat tight. Again, the new window was open for all the students. That also closed the school.
So therefore, according to you, after 7 January, there is a difficulty.
Total.
No. How you can, what arrangement can be made? Please.
It's a special case if a lordship directs.
Well, before that, the school has approached the board thrice.
That is prior to that. After
Baba.
the closing of portal, I have checked with him. Well,
Kindly see the last date. The last date is
7 January.
7 January. When I made the representation,
representation
online process.
Yes.
But when online process failed, we the headmasters, why we will be against the students?
Show me that you have made attempt to feed the
yes.
forms.
Now, yes. Now, kindly have a look to my two.
But that was failed. Where is the printout?
May I?
Before 7 January. Or last date was 7 January. So,
kindly see these two documents which I have presented before the board. Here we are to help the student. Kindly see when we wrote the letter to the board. We approached the board did not show us the sympathy.
No representation was required.
Because
there was a notification on 5th January 2025,
True.
last notification.
True. But the difficulty is, as the student is enrolled to other school, it is the board.
No. That the submission.
You tell me when transfer took place.
2023. Thereafter, the school should have informed the board and taken permission that say this student will appear from my school in 2025. You kindly get it. Is that letter in 2023?
তোমার বলা শেষ?
না আমি মাঝখানে আবার
তাহলে তুমি কমপ্লিট করো না তারপরে বল।
Yes.
The thing is, we approach the school also, the Shorisha. Both the schools have to approach the board. Now, we have approached the board. There is no fault on our part. Your lordship kindly show some sympathy so that he can sit for the examination, which will start in February.
I'm
12th February.
No, 10th February.
10th February. 10th February.
So my instruction is if your lordship directs, will allow because there is no fault of the student. But school is at fault.
The school passed class 9 examination from the present school.
Yes, from the present school.
That is more important.
Still the school have not informed the board. It should have informed in 2023 that along with my present student, this student will also appear.
We have gone to the board personally. The headmasters are not against the students. We are appearing before your lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Who is the petitioner? Father of the student?
Yes, father of the student.
Father of a student of class 10
That's right.
has approached this court with the present petition with the prayer to complete the registration for his son and enrollment, registration and enrollment
Registration is done. Registration is done in.
But it has to be changed.
No, my lord, there is no provision of change. My lord. Why I submit your lordship? There are this registration, this transfer system started only because this transfer in classes started only because to avail the facility the government submit. Because at a class, their wards they get admitted somewhere. The 9 they reach somewhere, they get registered somewhere. In 10 the father get transferred somewhere else. They also have to go. So, my lord, registration is cannot be changed. Only in class 9, the petitioner or any candidate reading in the school in class 9 from there once registration it is remain. But in the
but that will not prejudice the petitioner in
no
because in the in other
no, in admit card the name of the school from where she is appearing will be there, and that admit card and result and all certificate.
in all other documents relating to his Madhyamik examination shall contain the name of the present.
Yes.
So
Because
therefore,
no,
that correction is not
required.
Or registration is done on the enrollment district.
Only, yes. Only for us to understand that in 2020, if registered today,
With the prayer to complete the registration for
No, with the prayer to complete the process of enrollment, which would permit the petitioner to participate in, which would permit the student to participate in Madhyamik examination 2025, ensuing Madhyamik examination 2025, which will commence from 10th February 2025. So, it is submitted on behalf of the petitioner that the student was studying in class 9 in Sorisha Ramkrishna Mission Shiksha Mandir, South 24 Parganas, and took transfer on 6 January 2023.
Page 16.
And thereafter took admission in Mudhumgram PM High School within bracket HS, Purbo Bardhaman. Stop.
For the transfer.
Petitioner passed class 9 annual examination from Mudhumgram PM Girls High School. Mudhumgram PM High School within bracket HS. Stop. However, during the period when student. However, during the period when the student was studying in Sorisha Ramkrishna Mission Shiksha Mandir, on completion of formalities, registration certificate was issued in his favor. Stop. It is submitted in spite of issuance of registration certificate unless formality relating to enrollment is complete with the assistance of the West Bengal Board of Secondary Education, as well as the school where the student is presently studying. He will not be permitted to participate in Madhyamik examination 2025. Stop. Next, by a learned advocate representing West Bengal Board of Secondary Education, in reference to notification dated 5th January 2025, submits that as per the said notification, last date for taking steps in order to enroll the student for Madhyamik examination 2025 was 7 January 2025. Stop. It is also submitted prior to the time which was accorded to the schools and students to complete the enrollment in terms of notification dated 5th January 2025. From 6th January 2025 to 7th January 2025, in two different phases, opportunity was given to complete the process of enrollment, first phase concluded on 18 December 2024 and the second phase concluded on 3rd January 2025. Stop. According to the board, in spite of 3 opportunities granted, petitioner and the student and the school of the student did not take steps for enrollment, for the enrollment of the son of the petitioner, or for enrollment. Stop. It is also submitted on behalf of the board that correction of registration certificate, next paragraph, it is also submitted on behalf of the board that correction of registration certificate wherein name of the previous school is indicated is not required, since on completion of enrollment process, all future testimonials relating to participation of the student in Madhyamik examination 2025 shall be issued containing name of the present school. Next paragraph. On behalf of authority of Madhyamgram PM High School within bracket HS, it is submitted that effort was made by making representation to the concerned authority of the board for completing enrollment in connection with the son of the petitioner, but the process could not be completed. However, nothing has been shown on behalf of the said school authority that steps were taken online to enroll the son of the petitioner. Next paragraph. Without entering into the allegations and counter allegations which have been leveled by and between the board and the authority of Madhyamgram PM High School within bracket HS, it is required to direct the board and the school authority and the said school authority to take immediate steps to complete the enrollment process in order to permit the son of the petitioner to participate in Madhyamik examination 2025. Stop. On completing the necessary formalities and payment of late fine, concerned authority of the board shall enroll the student by 7 days from the date of communication of this order. Stop. Next paragraph, it needs to be recorded herein, since it is already submitted on behalf of the board. Now, it needs to be recorded here. Since it has already been submitted on behalf of the board that after enrolling the student, all testimonials relating to participation of the son of the petitioner in ensuing Madhyamik examination 2025 shall be issued containing name of the present school board is not directed to issue fresh registration certificate incorporating name of the present school. Next paragraph. The writ petition stands disposed of, there shall be no notice to post. এটা কত নম্বর হলো?
Only one line to be added, well, offline, because online is complete. Only one line offline.
Please, কি সেন্টেন্সটা বলুন?
And as a special case.
যেখানটা ডিরেকশনটা টু কমপ্লিট দ্য এনরোলমেন্ট।
order process. 28 12 44 688 at least 611 concern of sitting of the board shall involve the student.
না, অন কমপ্লিটিং টাইম এর পড়ো। অন কমপ্লিটিং ওইটা একটা সেন্টেন্স।
On completing the and calculate fine after completing of the board shall enroll the student
on offline mode as a special case.
Great.
Yes, call the matters from the combined list.
Item number 252 of the monthly list of approved site.
Lord, I am appearing on behalf of state. Lord, I am appearing led by Mr. Supriya Chattopadhyay.
আচ্ছা, আরেকটা লাইন অ্যাড করে দাও তো। Leave is granted to the learned advocates representing the parties to communicate this order, to communicate server copy of the order. Now, to communicate this order without waiting for the server copy of this order to the board for taking necessary steps.
And that's a one line of caution to the school.
Next, yes.
This matter leads to my lord compassionate appointment. My lord, impugned order rejecting my prayer is at page 22, relying
Which page?
22.
এটাই লিখেছেন? তুই দেখেছিস?
So the parameter of financial hardship does not support your case.
Yes,
That-
ma'am.
But this,
Where is the wrong in the order?
my lord, this
আমি জিজ্ঞাসা করেছি
type of order, my lord, on the basis of this circular, another rejection was challenged before this honorable court. My lord, this honorable court held the family pension is the right of the deceased family that cannot be equated with the family income.
Whether while deciding that writ petition with an order of the single bench,
Yes.
whether the division bench order in Anirban Chaudhary was considered.
No, here Balbir Kaur, Govind Prakash,
There is a decision of our court of the division bench headed by Justice Dipankar Dotto,
Justice Dipankar
where
Dutta.
it has in Anirban and Arindam Chaudhary. Anirban and Arindam Chaudhary, it has been decided that beyond the scheme, no appointment can be given. They'll file your affidavits.
Anirban Chaudhary.
Justice Dotto sitting with Justice Vivek Chaudhary. Order was passed.
I'll consider.
Then I had the occasion to author another judgment sitting with Justice Dotto in the case of Azim Daji. But exhaustive judgment is Anirban and Arindam. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, order dated 1st September 2023 passed by the District Inspector of Schools within bracket AC, Dakshin Dinajpur, has been questioned, whereby prayer of the petitioners to grant appointment on compassionate ground has been turned down. Stop. On next paragraph, on perusal, on next paragraph, state respondents are represented by learned advocate. Next paragraph, on perusal of the impugned 1st September 2023, this court finds it fit to call for affidavits to adjudicate the issue involved in the writ petition. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Affidavit in reply thereto, if any, be filed by 1 week, by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavit. All the parties are present today.
Yes.
I am appearing on behalf of
Party.
School authority made party has served.
Yes, the land advocate, next paragraph, land advocate representing the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file affidavit of service on the next day.
I'm deeply obliged.
আপনি স্টেটে সবার অ্যাপেয়ার করছেন
Next.
তাহলে শুধু স্কুল
I'm deeply obliged.
Item number 253. My lord, I'm for the state. Let the Mr. Vivekananda to party.
Now for the respondent number 6.
Yes, what is the matter of?
The matter relates to release of pension on the petitioner, my lord, and I am the first wife. The petitioner is the first wife of the retired assistant teacher who subsequently died in the year 2023. And my lord, since she is the first wife, subsequently the husband of the petitioner married again. There is a second wife. The pension is released on her behalf. And after the death, my lord, now I am claiming that since I am the first wife, in view of the death cum retirement benefit rules, when there are more than one wife,
You are the second wife.
I'm the first wife.
So why pension was sanctioned in favor of the second
Because,
wife?
my lord, in the pension paper, the husband put her name, but I am entitled, and subsequently,
But how the government has granted it that in presence of first wife, how the second wife was granted the pension?
My lord, just to recapitulate, on the last occasion when this matter was called up, your lordship had directed the petitioner and the respondent number 6, who is the second wife, to come to a settlement and have a talk between themselves. But then again, I don't think it
no,
is.
my lord, that was not the direction, my lord. In the previous occasion when the matter was heard, and subsequently, my lord, into the honorable coordinate bench.
Second wife is also alive.
Yes, second wife is alive.
So then
I'm the first wife.
you are representing
I'm the
second
second.
wife and
Yes.
you are in receipt of pension.
Yes,
my
So
lord.
how pension was granted to you?
My
Because
lord,
the second marriage is null and void.
But it is a Mohammedan law. The Mohammedan law.
So a permission is required. There is a circular so far the employees of the state government
My lord, initially, my lord, from the 1995.
Employee has to obtain permission from the employer.
Yes, that's it. But
Where is that permission?
I don't have, my lord, copy, my lord. Kindly, my lord, a report is filed on behalf of DI, my lord. Kindly peruse that, my lord.
the Honorable Coordinate Bench in the previous occasion directed the DI that the private respondent and the petitioner, that there will be a meeting between them, and in view of the meeting, my lord, the report is submitted before this court. It was directed that the petitioner is entitled to receive the pension amount.
Report is dated 1st March 2024.
Yes.
Yes, my lord. And report filed on. Yes, your lordship.
List.
There are 5 mentioned. Loan amount is.
এখান থেকে পড়া কোর্ট থেকে পড়া কোনো
না না সেটা না ঠিক আছে
এটা যা
আমার দিকে
পোস্ট অফ উঠে গেছে এটা অর্ডার পাওয়া কি কম্পিউটার উঠে গেছে আবার কি এখান থেকে ওটা চেঞ্জ করতে হবে নিচ থেকে চেঞ্জ বলতে হবে
আপনারা জানেন পেটরা জানেন
You are in receipt of maintenance under section 125.
I used to receive, my lord, and subsequently that was stopped, and I prayed for some enhancement, but again, it was irregular, and I never received the amount. And subsequently, my lord, the husband went for dissolution of marriage. That was rejected.
হয়ে গেছে
So both will get
Yes,
equal shares.
yes, my lord. That is
My lord, equal share, my lord, and my lord, kindly see, my lord, para 6 of the report, my lord.
Kindly peruses the report which I submitted on the earlier occasion dated 7th of May 2020.
Right, on the previous occasion, the state respondent submitted report, and wherein it was also specifically held that the petitioner is entitled to receive at least the half amount, and also along with the areas that he has never received.
That would be evident from paragraph 6 of the DCRB rules.
Yes.
Paragraph 26.
Para 26, chapter 7. Equal share will be given to the both wife.
Just a minute, just a minute. Wait. Now, from which date pension has been paid? From the date following the date of death of the husband.
No, my lord, from the retirement.
It's a case of family pension.
Yes, from the
So when the employee died, when the teacher died,
my lord, that was much later actually. He retired from service.
when the day, because there will be a claim of arrear amount.
That has been paid. Every single farthing
To the
from
second
the
wife.
side has been paid.
Only to the second wife. Only to
The
the
second wife.
Second wife.
Now the petitioner being the first wife, he is entitled to receive the pension. He is entitled to receive pension from the date following the date of
My lord,
Correct. However, what
how
happened?
this will be compensated?
That is the question, ma'am. Now we have paid from the state side. We have paid every single farthing, whichever was due. Now the pensioner had actually, while he was alive, he had taken out a loan of 2 lakh rupees, and from each month.
Which wife? First,
No,
second wife.
Pensioner
When he
himself.
was alive. When he was alive, subsequent to his retirement, he took up a loan of 2 lakh rupees against his pension amount. And every month it was getting deducted. Now, after the death of him, this amount, the respondent number 6 is actually claiming that no, if you want the pension, you will also have to pay the share of that particular loan. And their contention is, the petitioner's contention is, I haven't received any pension so far, despite being eligible.
How can
When the teacher died?
When the teacher died.
Yes.
When
teacher died.
Teacher died 18th August 2023.
Correct.
After that, all the amount, my lord, everything, pensionary benefit, everything, the second wife is receiving from that date. After that. And how can I pay any loan amount? I haven't got
If
family
half of the family pension,
which she is entitled to,
half of the family pension from 19th August 2023, if is calculated, then during which period this loan is to be repaid?
Sir, may I
120 installment.
Rupees 2 lakhs. And that was taken by the deceased husband of the petitioner. Now, during his lifetime, he had already paid 58,000. So now the amount left is only 1,42,000.
Along with interest.
Yes, and yes, 1,42,000 is the loan amount.
Principal amount.
Principal amount that is required to be paid, and the EMI was, my lord, on rupees
2,900.
Yes, that was the EMI amount. So 1,58,000 is the principal amount along with the interest that is left. However, my situation is that, my lord, I have never received any amount. Now I cannot pay the loan amount for the.
No, but in terms of Rule 26, petitioner is entitled to get the half of the family pension. and especially when the suit was dismissed, where that employee teacher prayed for a declaration for declaring his past marriage null and void.
Yes,
That suit was
that was this.
That is clarified.
so therefore the first marriage cannot be considered as void marriage.
No.
And petitioner has got right to receive pension from 19th August 2023.
Pension, yes.
So you need to, the DI is required to make a calculation sheet or prepare, make calculation showing that if half of the amount, considering the half of the family pension is taken into account, then whether this loan would have been repaid or not till February till January 2025.
My lord, I understand what is falling from your lordship. May I give a suggestion, my lord, which I was just telling both of them. My lord, just to settle this issue. Now, they have been getting, respondent number 6 has been getting the pension all this time. She has accumulated certain funds, she has got it.
But she is not entitled to get the pension full amount. Half amount he is entitled to get.
All this while she is getting the full amount.
And the petitioner has got nothing so far. There is a loan of 2 lakh rupees. They are both eligible for half of pension. Whatever has happened, let us not delve into the past. Going forward, let the respondent number 6 clear of that loan. Only 2 lakh rupees is left. And out of that,
1,42,000.
out of that, a certain amount has been paid towards principal and towards interest.
By the
Majority
petitioner
in-
and
out
by
of
the husband of
20
the
months of
petitioner.
EMI, on the initial years, majority of the amount would go towards interest. Only a little bit would be there for the principal. So if we get a direction from the bank, though the bank is not a party, so I cannot furnish that.
That is that calculation is required.
Now, what is the amount left? Now that amount, if the respondent number 6 pays it off, going forward.
Whether
we
you
can
are
split
paying the loan.
My lord, because this is a family pension loan, what happened in the pension loan, my lord, they just, my lord, give the account of the pension and it is automatically, my lord, deducted. My lord, it is deducted when the employee was alive. Thereafter, after that is continuing the same
From the
process.
family pension, it
From
is
the family
deducted.
pension, it is because of that, my lord, it is a pension loan. And bank, by taking the consideration of the pension amount, bank give the loan, my lord. So if that is the pension, it is a pension loan. If the employee give the pension loan amount, EMI in every month, EMI installment, then whosoever got the family pension, she or he whatsoever.
So
is
from the family
pension,
pension
yes,
account,
each and every
deducted.
month, yes.
Now whether the loan is repaid or still the loan account is
Is still continuing. That's my instruction. There is still remaining. May I suggest one thing, my lord? Because that is the I think about this matter because of that, my lord. If my lords hold it, if I that suppose the from today whatsoever amount 50% to the petitioner as well as 50% to the private respondent, whatever amount paid to the loan as an installment, yes, after deducting EMI. Now start from today, whenever my lord pass the order, whatever the amount, the loan amount, after that the petitioner will give as well as the half amount because of they entitled both the petitioner as well as the private respondent entitled 50%. So they also give the 50% from that day. So everything afresh will be started from that day. Otherwise, my lord, what happened?
But what will happen so far the area claim of the
Yes,
petitioner is
yes,
concerned?
that's why I propose this. Because of that, if my lords hold so, suppose as a area payment, you have to pay it, then my
There is no difficulty because as you have as you have submitted that suppose the pension family pension is 500 rupees, 100 rupees is EMI, deducting 100 rupees, 400 rupees is paid. Now in terms of rule 26, 400 is required to be divided into 200 plus 200. Yes. So therefore the DI would make calculation excluding the EMI that what was payable to the petitioner from 18th August 2028, 18th August 2018.
2023.
No.
18th August 2023. Now suppose if it is found that 1,20,000 should have been paid to the petition in terms of Rule 26, then that will be deducted from the family pension of the respondent number 6 in installments in order to clear the arrears.
My lord, may I submit one thing, my lord?
Because there is no issue. I was under the impression that the wife, the respondent number 6 was required to pay the loan amount. That is not the arrangement. Arrangement is this, that this EMI is to be deducted
From the
automatically from the family pension account.
Because that is a
Now,
pension law.
family pension is EMI is being deducted from 19th August 2023. After deducting the EMI, 50% will go in favor of the petitioner, 50% will go in favor of the respondent number 6.
Yes.
Now, so far this process will continue till repayment of loan. Thereafter, the 50% amount will get enhanced. Now, therefore, what was payable to the petitioner, that will be determined by the district inspector of school being the pension sanctioning authority, and in equal installments, equal suitable installments, that is to be deducted from the future family pension of the petitioner respondent number 6.
My lord, may I make a submission? Because
Yes.
my lord, may I submit one thing? Because of that, my lord, the petitioner, my lord, represent whatsoever the document present before the authority, that is a genuine document. He is not never misrepresentation. There is no such misrepresentation. So petitioner, sorry, I am usual respondent number 6, my lord, never misrepresent herself before the authority, my lord. Authority sanctioned the pension in favor of the respondent number 6, and petitioner was not staying with the employee. It is a fact since 1995.
For that, you
I just place it.
deny the family pension
Yes,
to
yes.
the petitioner.
Yes, I place it, and madam, you will get opportunity. Madam, you will get opportunity. So petitioner have a single daughter, my lord, and petitioner already. I place it in lieu of, my lord is well aware of the fact. Because of that, my lord, misrepresentation.
Don't make it. Don't explain it very widely.
My lord, petitioner never. My contention is that, my lord, respondent number 6 never misrepresent herself, and the authority gave the pension to the respondent number 6. If the authority, if either my lords have to hold it, the authority gave a wrongful payment. If my lords, yes, then my lord petitioner, my respectful submission is that if the authority gave a wrongful payment, then my lord, why I will be punished? That's my submission.
It's not a question
Yes,
of punishment.
yes, my lord, kindly consider it. Kindly.
You are not entitled to get 50%. You have wrongly received.
My lord, I never miss that. That's why my lord, misrepresentation was not there. My lord, kindly, my lord, visualize it. There is no such misrepresentation. There is no such. Otherwise, it is a civil.
Tell me the date of retirement.
Yes, ma'am.
My lord, it is otherwise it is civil in nature. Then punishment is the only.
2019. 2019. Then died on 18th August 2023.
2023.
Regarding your
Then, my lord,
although extremely wise, my lord, however, one small query, my lord. Over there, would the DI be able to calculate, because that is a
Court will direct to calculate. DI is the pension sanctioning authority.
Yes, my lord, but that is between a bank and the
No. Bank is in no way is affected. Bank EMI shall remain intact in terms of the loan agreement. That will not be tweaked by the order of this court. Only thing is the risk, deducting the loan EMI, whatever will be there, that will be divided 50%, divided in equal share from the month of February 2025. From the month at the time of making payment of family pension, from the month of February 2025, or from the month of January, family pension is to be paid in the month from the month of January 2025. So far, the arrear amount from 19th August 2023 that will be calculated by the district inspector of schools, that what was the amount payable deducting the EMI to the petitioner. That will be calculated and that will be deducted from the family pension of the respondent number 6 in equal suitable installments.
That suitability, kindly, it's affect me, kindly
Petitioner
consider it
being
in
the
that
first
point.
wife has come up before this court with the present writ petition for direction upon the state respondents to release family pension in his favor. In her favor. Stop. It is submitted that petitioner was the first wife of one Chaudhuri Saiful Haq, who was an assistant teacher in a madrasa or a school?
High school, my
High
lord.
school.
High
In a government aided high school. Stop. The first marriage was solemnized on 3rd April 1993. Stop. However, from the report dated 1st March 2024 of the District Inspector of Schools within bracket AC close bracket Murshidabad, being respondent number 3, it is revealed that in 1999, state teacher executed talak Now, state teacher divorced the petitioner on executing talaknama and subsequently filed a suit being 211 of 2015 before the civil court praying for a declaration that the said talaknama was valid one. Stop. It is also revealed from the report dated 1st March 2024 that a suit was decreed on 4th February 2020 without interfering with the marriage which was solemnized by the teacher, solemnized by an in between the teacher and the petitioner. Stop. However, the teacher married once again with respondent number 6 in 2002 and included name of respondent number 6 as his nominee in connection with his service being an assistant teacher of a government aided secondary school, government aided high school. Stop. Teacher died on 31st January 31st. Now, teacher retired on 31st January 2019. Thereafter, he was in receipt of pension. Stop. Teacher died on 18th August 2023. And from 19th August 2023, respondent number 6, being the nominee being the nominee has been receiving entire family pension. Stop. Sanction of family pension, next paragraph. Sanction of family pension denying right of the petitioner to get 50% of the same triggered this writ petition at the instance of the first wife, and in connection therewith, and in connection with the present writ, and in connection with the same, on filing a report on 1st March 2024, respondent number 3 has stated that the petitioner is entitled to receive 50% of the family pension on the strength of note 2, rule 26 of the death cum retirement benefit scheme 1981. Stop. 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 The note to rule 26 of death of DCRB scheme 1981 is quoted below. এটা কোট করে দেবে, বুঝতে পেরেছো? Is quoted below. Stop. During course of hearing, nothing has been shown on behalf of respondent number 6 which can disentitle the petitioner from receiving 50% of the family pension. Stop. However, fact remains, respondent number 6 has been receiving family pension from 19th August 2023 till date. Stop. Next paragraph. In view of the relevant provisions as alluded above, now, in view of the relevant provisions of DCRB scheme 1981 as alluded above, state respondents are directed to pay 50% of the family pension to the petitioner from the month of January 2025, which is to be paid in the month of February 2025. Stop. Next paragraph. During course of hearing, it has been brought to the notice of this court that a loan account was existing in connection with the pension account of the husband of the petitioner, and after the death of husband of the petitioner, EMI is being paid on directly deducting the amount from the family pension which was being paid to respondent number 6. Stop. If the loan account if the loan account still survives, in that event, after deducting EMI, rest of the family pension shall be divided in between petitioner and the respondent number 6 equally. Stop. Next paragraph. Since petitioner is entitled to receive arrear family pension from 19th August 2023 till the month of December 2024, respondent number 3 is directed to calculate the total ADR family pension which is payable to the petitioner after deducting EMI and same shall be recovered from the future family pension of the respondent number 6 in equal suitable installments. Stop. Stop. In this regard, the respondent number 3 is directed to pass an order after granting opportunity of hearing to the petitioner and the respondent number 6 or their representatives by 8 weeks from the date of communication of this order. Stop. After the order to be passed in terms of this direction, payment of family pension shall be made in favor of the respondent number 6 in terms thereof. Next paragraph. Writ petition stands disposed of, there shall be no orders to cost or then xerox service.
If I may ask for a clarification here, my lord, the petitioner is entitled from the upcoming month.
Yes. From the month of December, January, which is to be paid in the month of February 2025. So for area, I will pass a result order that what is the amount payable. Suppose X amount is payable, is found payable to you. That is to be recovered from the respondent number 6 upon fixing the installments, quantum of installments and number of installments. To that extent, after granting opportunity of hearing to both the parties, final order is to be passed that how this recovery is to be made, what would be the quantum of installment and what would be the number of installments.
I am extremely grateful. I am extremely grateful, my lord.
Kindly fix the number of installments.
No. That is no, never.
Unless until the amount is determined, court is not in a position to fix the number of installments.
My lord, and
because some amount should go in favor of the respondent number.
No doubt.
After deduction.
My lord, from the next month, respondent number 6 will also get the 50%.
50%. Yes.
Kindly clarify. Otherwise, my lord,
No, that I have clarified adequately.
Grateful, my lord.
Yes, it's called the fixed matter.
Extremely grateful, my lord.
Item number 135 from monthly from daily list of appellate site.
No, now I cannot say anything. Please give me some time. Yes.
My lord, I appear for the petitioners, my lord. My lord,
You will start.
Lordship, on the last occasion, my senior Mr. Mojumdar, my lord, had
Just a minute.
Lordship.
Which one was it?
Yes. Mr. Rai, you are avoiding this court, I find.
Your lordship, God for me, I am here, my lord. It is a subject which I have got no knowledge about, but still I am here.
No, there are some matters where the assistance of.
My dear Lordship will kindly direct, I will definitely appear, my lord.
Yes.
But I am so much overpowered with giving and distributing matters, but I really get to matters.
Yes, please.
Whenever your Lordship needs me, my lord, kindly, my lord, I have never.
My lord, as my lord placed by my senior on the last occasion, my lord, the gist of the matter is this: the petitioners, my lord, are the pensioners in relation to KMDA. My lord, previously, my lord, they were the employees of Kolkata Improvement Trust, KMW.
Where is Mr. Majumdar?
My lord, he's on his legs, my lord. He will, my lord, come. He's on a fixed matter, your lordship. My lord, may I hold the brief on his behalf, my lord, till my senior comes.
Just a minute. You filed a list of dates.
My lord, a written notes of argument was filed, and my lord, compilation of judgment was also filed on behalf of the petitioners.
Just. Yes, please.
My lord, petitioners were the pensioners of, my lord, employees of Kolkata Improvement Trust, Kolkata Metropolitan Water and Sanitation Authority, and my lord, KMDA. Subsequently, KIT and KMWSA merged, my lord, in 2017.
2017.
2017, my lord. My lord, each of the petitioners had commuted either 1/3 or 40% pension at the time of superannuation. This 40%, my lord, this was
I'll
enhanced.
hear you, Mr. Rai. The issue is there is a difference which is going on in between KMDA and the state government finance department.
No.
Now there is that pension scheme was introduced in terms of a specific rule which has been relied upon by Mr. Majumdar from the very beginning, where the pension was started and the employees of KMDA, they were permitted to commute part of the pension. Now, this commutation was for a period of
15 years.
15 years.
I have not got that much.
This commutation was for a period of 15 years.
But I am not aware of that. But
Yes, this commutation is for a period of 15 years. Suppose I am getting pension 100 rupees. Now, out of 100, is now the latest is 40% or 33% commutation?
40%.
40%. Now the 40% is commuted for a period of 15 years and a lump sum amount is paid to the employee at the time just after retirement. 40% of pension in each month for a period of 15 years. Lump sum amount paid to the employees of KMD. Now, after 15 years,
kind doesn't take me. This 15 years thing is not there. That is the distinction between the state pension rules, TCRD rules, and this rule.
In everywhere you will find
it is not here.
It is not here.
It is not here. So the question will be whether your lordship will be reading this into this rules. Whether this court will be called upon to, I should be saying this legislate is not the word, to incorporate, let us say, incorporate
and read 15 years into it, read the restoration provision into it, and then give it a retrospective effect. That is what your lordship is being called upon to do at this moment.
Under the rules,
It is not
there is ways and means.
There is no. I know mooted is that has not been correctly dealt with your lordship. It has not been correctly done. So if your
No,
lordship,
but if that restoration of commuted part of pension is not permitted, then it will lead to a preposterous situation.
no, it won't. May I say this one? But what is commutation? Let's try to understand what I have understood. I'm a new student, so can does not take me.
Yes, yes.
Can you correct me? Commutation is basically where an employee sells his part of the pension to the extent allowed under the rules to the employer. In lieu of what? In lieu of further higher rates. It's a combination that you give 40% and you get higher rates, and that is the commutation. Now, this, with humility I submit, is in the nature of a contract. Nowhere is an employee put under a gun or under any other rules or statute that he'll have to take it. No dispute about that. So, when he's taking that, let us say in these rules, when he's taking that, he's aware that there is no 15 years. He's aware that there is no restoration. So the purchase price remains only that. In, let's say, in case of the West Bengal, the regular rules, when I say so, the state employees rules, there that is mentioned.
You give any instance apart from these KMD employees, that restoration of commuted part of pension is impermissible.
I never said that. I said it has.
You won't find anywhere.
I'm saying it has to be by the rules.
Everywhere, teachers,
everywhere,
professors,
then
the employees of the state government, everywhere. That is the concept.
They have been notified from time to time. They have been notified from time to time. It's not as a matter of right, but as a policy it has been given. It's a matter of policy by which it has been given in certain cases. Education, some others, your lordship has mentioned have been annexed here, well, fine. But it's not as if it's a mandate. It's not a mandate. We are here, my learned friends are invoking a great jurisdiction. So what I'm trying to say, they were always governed by these rules. No dispute about that. If they were governed by these rules, when they sought to sell their part of the pension, they knew at what price. They were well aware that 15 years is not going to be there. They were well aware that the price does not include the restoration, which also is a part of the price, because in other cases in 15 years time, the entire pension becomes full again, so you get that money again. But here it is not made available. But kindly does not take me, I'm only on the law.
Is there any provision in the rules which you are referring to that once commuted that it will be that the pension would be deducted for the rest of the period?
But commutation means that part which you have commuted will be deducted from your pension
for a limited period.
But that limited period is not there, and it is on restoration. The provision of restoration is right also. Only on that provision of restoration, that the pension again becomes.
So the situation is like this: if 100 rupees is pension, 40 rupees is commuted per month for a period of 15 years. For a period of 15 years.
But that is not the.
For a period of 15 years, this is for an instance.
No.
Then, if I accept your submission, Mr. Rai, in that event, after this period of 15 years, the pension to be paid to the petitioner at the rate of rupees 60.
But may I again try and establish what I am saying.
Pension to be paid at a rate of rupees 60.
Again, yes, may I say this one? Kindly appreciate. There are two situations here. One, I'm trying to bifurcate both. One where there is a provision, commutation will be for 15 years and there will be restoration after 15 years. And commutation with humility method is not a deduction every month. Commutation happens once, or if allowed by the rules, twice.
On calculating month by month deduction for a period of 15 years.
Again,
33% previously, now it is 40% month from the pension for a period of 15 years.
Again, may I say?
If it is not month by month deduction, but at the rate of 40% of the pension, which is payable to the pensioner for a period of 15 years.
This will be what? In lieu of what? That is the question. But in lieu of what? What does commutation give the person concerned?
The sum of amount.
Which is much higher.
But
higher.
for that, whether the pension can be reduced after 15 years.
Malak, that is what I am submitting, Malak. This reduction of pension is a matter of Malak commutation. Because that 40% has been commuted. Therefore, pension is less than 40%. Then going back after 15 years, this part, Malak, which is following from your lordship, is again Malak by the rules. If the rules are of restoration, that means the pension will again go back to 100 after 15 years.
Otherwise, after 15 years,
there is nothing.
There will be reduction of pension to the extent of 40%.
15 years.
Calculation is 15 years. Yes. No, otherwise, on what basis calculation was made?
Calculation?
Yes.
Let us say that regular pension is, let's say, let us say 60 rupees. 60 rupees, they are commuting. Now, they will say till what time they are going to commute.
No.
The period.
The period was determined by the authority. Ask KMD authority. How the yes, they are representing Mr. Tamilkar. How the calculation was made. Only option which the pensioner could give whether he would commute or not.
But kindly sees
he cannot commute for a period of 5 years. That was impermissible.
Let us see first the rules.
Yes.
Rules.
Yes, you please take your seat.
They have finished more or less. Legal
No, and certain things I need to consider because for a long period of time I could not hear the matter. It was a hardened part, but due to change of determination, I could not hear.
I have not filed that matter, but you can grant me that please submit later. This chapter 9, commutation of pension. And that would be internal page 19.
Yes, internal page, rule 38.
Yes.
Rule 38. Page may not tally, rule 38, yes.
An employee is eligible for pension under this shall be entitled to commute for a lump sum payment at the rate indicated in annexure to any portion not exceeding 1/3 of his pension, which has been or may be granted to him under these declarations. That is not required.
Now come to annexure 2.
Yes. So that will be at page.
Show me annexure 2.
Yes.
Yes. Yes, annexure 2. Annexure 2. Yes. Vida regulation 38. Yes.
Commutation value for a pension of rupee per annum.
Age of next birthday commutation will be expressed as number of bits purchased.
I'll make two submissions. One with the 15 years, one without the 15 years.
Commutation will be expressed as number of bits purchased. Yes.
So, let us take your lordship's first example. The 15 years is dead in. I'm taking that first, and then I'll come to the next. Even if 15 years is included into this, my lord, the point of restoration is not here as a matter of right. My lord, I'll show the other rules, my lord. Your lordship will, my lord, I'm sure your lordship has seen that. It is a specific rule under which restoration is allowed. Now here, my lord, it is not there. It is well known because KMD also sought for an amendment, and my lord, Mr. Mojumdar also is aware of that, and that is why he's taken a alternative argument of my lord, mutatis mutandis. I'll come to that later, my lord. But with regard to this, my lord, even if 15 years, then also, my lord, your lordship will find that my learned friends, clients, would always be aware that they don't have a right of restitution. My lord, this addition to the, let's say, 60% pension to make it 100% is not due to the commutation, but it is because of the right of restoration. That is the meaning of restoration. That even if you have committed after 15 years, your pension amount will again be restored. That is the meaning, what I have understood. Now the second point is, there is no 15 years written here. If your lordship kindly sees, my lord,
But what is the purpose of commutation? In order to get the money, or get the sum or a corpus in one go, so that the retired employee is benefited.
Yes.
But in the name of commuting a portion of pension, whether the pension can be reduced.
But when commutation happens, pension as a matter of course is reduced.
That's why I am telling Mr. Rai, you show
Therefore,
me,
your lordship-
apart from KMDA, any instance in any other service rules that after commuting, a retired employee is not permitted to have the benefit of restoration of pension after the period of commutation.
But again, I say, man, I cannot give examples right at this moment, but what I found.
This is unique so far KMDA is concerned.
Malad, this is what it is. The rules are here, and I'm sorry, Malad, I may sound very inequitable, but Malad, this is what I have understood of.
And after all, it's a pension regulations.
Definitely.
Yes, it has to be interpreted liberally.
I am also Malad there with your lordship, but does it require an intervention which would change the nature of a contract by a court? Where court is, if the court, but again, kindly does not take me away.
No. That's why I directed the learned advocates to inform you.
That is absolutely on the point of view. Now, if your lordship is today minded,
don't hesitate to advance your argument to up to any extent.
No, obviously,
yes.
Your lordship knows what extent I will go. I will not go any further. Now, today, if your lordship directs, let's say, at 15 years and restore, my lord will kindly be minded that your lordship will, one, rewrite a contract. Two, my lord, the employees here is the state, no problem. But my lord will require the state to act contrary to its agreement. Or my lord will be directing with humility, I submit, my lord, a breach of the contract. Anything beyond the contract is a breach. Good, bad, anything will be a breach. So the question is, this is a pure sale of pension. If there is a pure sale of pension, my lord, that terms and rules were always known. Now the petitioner wants that has to be read into it and also give a retrospective effect. But there are, as a matter of Mr. Mojumdar's judgments have wanted to help you to that extent, that you cannot have something when the person is superannuates, the law at that point of time will prevail. You can't give it a retrospective effect like this. That is what is being sought for today, from 2001. Why not from 87? Why 2001? So that is the scope. Now I humbly bow down because at this moment I cannot show you lots of other rules. I'll have to look into it. But even if that is not the case, this rule is binding. Today, Malad, Mr. Mojumdar therefore has made an argument that if your lordship kindly sees that.
No, but you obtain instruction from finance.
Yes.
That whether this is prevalent in any other
I
service,
obtain, I mean,
statutory service which is governed by statutory
I
rules.
just take instructions. From
Yes.
I have not taken that instruction because I was not.
Yes, yes. You will get time, no issue.
I take that.
You obtain instructions whether
May I say this?
on the premise based on which you are making argument, whether in the pension rules of employees whose pension and calculation and sanction of pension is governed by statutory rules contain such provision that
does not contain.
Yes.
It does not contain.
Yes.
But I guess it like it. My heart is otherwise, but I have to argue this way. I can't help it because that is what the law I've understood. So I take instructions on that. Now,
so first point which you are urging that rule is silent on this. Your rule is silent. There is no provision in the rule for restoration of commutation of pension after expiry of 15 years. And second thing is this: it's a contract. It's a contract in between the employer and employee. So therefore, any order which would tweak these terms, that would amount to breach of contract.
That is what. And it would do acting in variance of the content, and a court would never do that because not only it is obviously it's a welfare organization to understand, but from one side to another, it's also holding for others the responsibility to, or if I may say, to act in terms of the rules. The government also has that responsibility. So that would to give this interpretation into the statute would also may not inure to the benefit of the other part of the society for which the state has formulated the rules. Now, Mr. Mojumdar.
But another thing which I think I have called for a report from the finance department.
They have
a report has been filed where the points which you are urging today are not there. It has been the report is on report contents or report rather reveals the stand of the finance department that if this can be arranged by utilizing the fund of the KMDA, government has no authority. Government has no objection. But the state authorities or the finance department of the state we shall not provide any fund. But it has not been indicated in the report that due to absence of provision in the rules, it is impermissible.
But I think, may I just.
So therefore, the argument which Mr. Rai you are advancing today, that is perhaps not in sync with the report which has been filed on behalf of the finance department.
But I have here, there is no provision regarding restoration of committed portion of pension in the regulations for KMDA. This is the point taken by the finance.
Where? Just a minute.
I'm sorry, it's
just a minute.
I think February 2024.
Just. It is in the form of affidavit.
No, it's just says report of finance department.
Just a
minute.
It is also annexed in our exception at
page
11.
The report should be there. Yes, yes, report of the finance department.
And kind of takes page 2.
It is dated
2nd of February.
Additional Chief Secretary, Finance Department. Yes, yes, yes.
It's there.
Yes.
And obviously, I'm increasing the legal aspects of it. But the point is there that there is no such rule, there is no restoration available. And that state pension DCRB rules and this DCRB rules are different.
Yes.
That is it.
Yes, that's true.
That is it. So that point is there, Malad. Malad, if your lordship would, if I'm very technical, then yes, this should have come from KMB. My submission should have come from KMB. But Malad, for one reason, I have to say this, is because Malad, they have referred to regulation 52. The mutatis mutandis.
Yes, clause is there.
I takes that clause. And your lordship will find that
It is annexed to the writ petition.
No, the document which I just gave to your lordship, the rules, your lordship read rule 38 just after that.
Just. Yes, yes.
In
Rule 38. Yeah.
They had given certain parts were not there, so I gave the complete.
Yes, which rule you are relying?
52. That is what Mr.
Amendment of the regulations.
That is what he referred to. Well, kindly reads along with me. Well, I'm just reading it.
Yes, yes, please it.
Subject to the approval of the Calcutta Metropolitan Development Authority.
It says subject to the approval of the board. That is not just a minute. Then let me take your rule. Yes. Yes, there might be amendments.
Many have been annexed with the writ petition, also with the opposition. But now I've got one single one which gives everything.
Yes, subject to the approval of the Calcutta Metropolitan Development Authority.
These regulations may be amended or modified. So, there is a requirement of, if there is a requirement, it can be amended or modified mutatis mutandis. So, it would require an amendment of these rules in the same manner as in the model of the corresponding rules of the state government.
Yes.
So, we'll have to give some thank you to the first regulation 52.1. Now, let me read this next regulation.
That is more important.
Obviously, that's why I gave the first regulation because kindly reads it.
Yes, 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 yes.
I will only require your lordship to kindly take note. It is my submission. Generally, we find this act will apply mutatis mutandis. This section will apply mutatis mutandis. Your lordship will not find, but very rarely, that any matter shall be decided mutatis mutandis. These are two different things. So kindly reads two, my lord. Any matter not covered by these regulations shall be decided mutatis mutandis on the basis of the provisions in this behalf in the rules of the state government.
Yes.
So it is with regard to decisions if needed to be taken. What are these decisions? The regulation does not start at commutation and ends at amendment. It has disciplinary actions, when it can be withheld, when it cannot be withheld.
Any issue.
So if a decision is required to be taken and that decision making process is not incorporated in the rules, then that has to be mutatis mutandis with the state government rules. Now, if what in the manner which Mr. Mojumdar is reading this, if I read it as that, then 52.1 becomes ocious. There will be no requirement of 52.1. There will be no requirement of 52.1. If the second part said apply in place of decided, then 50-1 wouldn't have been there.
Whether you are trying to harp upon the issue that in continuation of the provisions in sub-rule 1, sub-rule 2 has been incorporated. That if after amendment following the model of the state government, if it is not covered.
If no, what I am submitting, this is only, the 52 is only related to any decision making rules, which is not here, but in the state rules. That is, I said, decided muted jurisprudence does not apply. Now, if this is let us apply, and the other way around, then one wouldn't be required. Then why?
Therefore, according to you, it is not automatic.
It is not, and one is only for if there is a need for application of any other rules into these rules, then amendment. If there is some,
but shall be decided.
Yes, has to be. Shall be decided. On the word decided, it does not apply.
So it is not automatic.
It is not at all anyway.
So therefore,
only decision making will be automatic.
So while the decision is taken, whether you can get any escape route, if similar provisions are there in the state government, because restoration is not covered by these rules, and there is no express exclusion of the restoration.
Restoration is a right. If a right is not given, exclusion is not required. With humility, it is a right. Restoration is again a right. Restoration is included in the cost price. If I maybe, I crude in saying it, but in the price for commutation, restoration is included there. Here it is not included. If you don't want it, don't take it. But these were the rules when it was commuted. So there is no decision here. With humility, I submit.
According to you, that no decision is required to be taken.
No. But as a matter of fact, I am also sought for merit because that I need to see that what is there in their applications, the format.
Which application?
The state government's applications format. I wanted to see whether it would be of any help to me. That's what it is here. I'll also look into that. But what I am submitting today, Melody, is if 52.2 is an automatic application of entire rules of the state, then 52.1 was never required.
So this inclusion of this particular word decided signifies a significant aspect.
See, so many acts, so many rules. Apply, decide here.
Provided any decision is required, then that decision shall be taken. Muted is muted.
Yes.
Muted.
Muted is one of the meaning. Again, I am helped by Mr. Mojumdar's judgments. It would mean changes as necessary without changing the basic nature of that. Let us say apply mutatis mutandis. Maybe the procedure is allowed to be applied. Does not mean the substantive right will also apply. The substantive right of that earlier act is other than what is there in the new act. So
in its usual course, it will apply in that.
But it would not change the basic nature. If only thing I was again saying if commutation is mingled with restoration as a whole, right, then yes, might be. But therefore, I also say this, my learned friends have also accepted that it was sent for amendment. AMD also says the same thing. They've all understood that this requires to be amended. This is, as I am making submissions, Mr. Mojumdar has also taken this point now, that mutatis mutandis, therefore it applies. But the understanding is always there. And basically, the petitioner wants a change of policy. That is the only thing. So this would be my gamut of argument, my lord. And I wanted to just, my lord, because I'm very new to this, so I was thinking about this. So this is what the, even as a matter of fact, the judgments have very well helped me to understand. So after she finishes, your
এই
lordship,
দেখি একটা শীট দাও তো সাদা।
চাবি তো হচ্ছে আজকে ছাড় না, কেমন করছিস? গরম লেগে কিছু ঘাম হচ্ছে।
Yes. Any judgments you are relying upon?
Well, let them complete, then may, only one more point, my lord.
Yes.
One is, my lord, when this DCRB rules of came, they came into came into force. Before that, my lord, the state rules were there. So therefore, my lord, it was left out with that intention, I believe. And another thing, my lord, I find that there is a
It's a
already
conscious exclusion.
left out.
Conscious exclusion.
So as a matter of policy, if it was like left out, my lord, to require again that policy to be taken, my lord, if, but then arbitrariness has to be shown in some form. Because I must point out, my lord,
But you don't think this is arbitrary? That after a period of 15 years, even if this court proceeds on this premise, that yes, there was no provision, as you are arguing that there was no provision for restoration, then on luring the employees to get the benefit of commutation, after a period of 15 years, their pension would be reduced to the extent of 40%.
let me just say. First of all, luring. And what said from the lordship is a very harsh term, but I must try and defend that. Lure would be, my lord, is the nature of cheating. I
No,
would have
it's
the
not cheating.
intention to cheat and therefore I lure that person that as if to make him believe that instead of 15 years, you'll get restoration. As long as they don't show that, I mean, luring may not be there. Rather, I would make a submission with open eyes. The other submission, the petitioners entered into this contract with the
But the result is that the consequence is that by that after the expiry of the period of commutation, substantial reduction of pension so far the pensioners are concerned. How would you accept this?
The prices of that percentage which are being sold out. Excuse me. Price is vis-a-vis that 40%, that 40% sold. Kindly appreciate that, madam. They are not entitled to the 40% unless provision of restoration is there. Madam, we are not deducting.
If I accept your
There is no
contention, there is
deduction.
a serious ramification so far acceptance of your contention is based on the statutory provision is rule is based on rule is concerned, that it's a way by which the pension is being reduced. How that is permissible?
Let us try.
Consequence is very, very serious.
That's right, madam. We are taking two things, madam. As
Then there must have been a specific warning or a provision that after the period of so and so there will be no restoration of commutation of pension or restoration of commuted part of pension.
Where was this before? Where did they, do they ever ask? They knew about it.
That's why I am asking you, Mr. Rai, you also try to, you will be able to, that is there any pension rules and provisions which are controlled and guided by statutory provisions having such harsh provisions
May I say this,
that by opting to get the benefit of commutation, they would suffer or they may face the risk of substantial reduction of pension.
There is a difference in this one. Your Lordship, I am not being able to make us clear. Malak, the reduction is a direct result of commutation. Kindly appreciate this one. Let us reverse it. Let us the basic principle, Malak. Commutation is what? That I will get 100 rupees as pension per month. I am commuting 30 rupees. So what happens? You are agreeing that, okay, take away 30 rupees, give me 70. But because I am giving you 30 at this moment as a reduction, you give me higher amount and you get it. The scope of this reduction increasing to the full amount of pension is not a result of commutation. It's a result only of a right of restoration, contract of restoration.
But the consequence is this: after 15 years, suppose this 40 rupees was not commuted, then from the date following the date of retirement, the employee would have received the full pension, that is 100 rupees. That has been reduced to 60. Now, after a period of 15 years, that employee or the pensioner would get this pension at a rate of 60 rupees.
My dear Lordship, with humility I submit, we are getting a lot of things into this.
But that is the effect. That is a direct effect of commutation.
If your Lordship, let us today, for the time being, just wipe away everything. Just let us look at this KVA rules, the DCRB rules. But can you only this one? Then I will come to the rest, the rest of the rules. Under these rules, if these rules were there, because your Lordship, I must say this, your Lordship has seen so much of these rules, Lordship finds this restoration in all
the rules.
So therefore, your Lordship is coming to that conclusion that 15 years is the general time period. So for 15 years only commutation will be made. After that, it has to be restored. That should be in the rules. But that is not what the rules say.
Do you come across the definition of commutation?
Well, commutation is.
No, but because I still
Should see it, but yes. I will bring it to your lordship.
there, have you before placing this matter, have you gone through the same? Is there is no concept of any period for commutation in service jurisprudence?
If it is given by the rule. It is given by.
Please go through the definition of commutation. In service jurisprudence, it always you will find that it is attached with a period.
Generally, it is always there. Generally, it is always there. I cannot decide from that. But the point is,
Find out the definition, whether it is attached with period or not. Yes.
But since the rules are such, the rules will have the primacy. Therefore, I submit, but again I submit. The restoration of the entire full amount of pension is a result of restoration. It is not a result of commutation for 50 years. This is a difference between both. Even if there is, I'm trying to say this, even if there is a commutation for 15 years, but no provision for restoration, then also it cannot be.
Then the employee will be compelled to get the pension at the reduced rate.
The employee got his money for that 30%. Let us say the employee, that's good, nothing happens, so that's employee, it's not a, within 2 days he passed away. Then he is at an advantage. So that age limit is something which, that is why it is to the contract. That is why it is to the contract. Today, if your lordship kindly,
yes,
they are saying that 30%. Whether I will give you back a further restoration as a bonus or not, that I think is absolutely on the employee. And if it was not there, then may I come back next week?
My lord,
yes, you will get time.
Get more organized in this one.
My lord, may I show 2 pages, my lord? My lord, page 139 of the writ petition. And this is dated, my lord, 27th
Just a minute.
October, lordship.
Page 139.
139 of the writ petition. It is dated 27th October 1998. Subject revision of pensionary benefits of state government employees consequent on
Just a
the
minute. Just a minute. Yes, 139.
lordship.
Yes, a typed copy is there probably
Typed
from
copy.
141.
141.
Yes. Yes, you place it.
My
You have heard the argument of other side, you place it. Give Mr. Mojumdar some time, breathing time, yes.
My lord, at page 140, your lordship will find that the maximum, there's a clause which indicates that the maximum amount of pension that can be commuted
Clause
as
1
clause 1 at page
of the
140.
memorandum dated 27th October 1998.
My lord,
Yes, just a minute. Clause 1.
clause 1
Just pension shall contract.
at page 140, my lord.
Yes.
The maximum amount of pension that can be commuted as per Rule 5.2 of the West Bengal Services Commutation of Pension Rules 1983 shall be raised to 40% of the amount of pension. Other provisions in the said rules will, however,
You are reading from which clause?
my lord, page 140 of the writ petition. My lord.
Yes, page 140. Clause 7 or clause. Yes, maximum amount of pension. Please read it. Maximum amount
The
of pension.
maximum amount of pension that can be commuted as per Rule 5.2 of the West Bengal Services Commutation of Pension Rules 1983 shall be raised to 40% of the amount of pension.
Yes.
Other provisions in the said rules will, however, continue.
Previously, it was 1/3.
1/3.
Yes.
Next line, my lord, the time limit of 15 years from date of retirement for restoration of commuted portion of pension will remain unchanged. My lord, these 40% was allowed. My lord, these 40% was allowed, and my lord, it was affected by KMDA, irrespective of the fact that there was any amendment in the, my lord, regulations. My lord, as placed by my senior on the previous occasion, your lordship, Rule 52(1) and Rule 52(2) of the CMDA regulation leads to one possible conclusion of, my lord, ruling out the role of state in either modifying, amending, or, my lord, mutatis mutandis, applying the corresponding rule of the state government. However, my lord, the benefits which was provided.
This provision, as you are referring to, as contained in memorandum dated 27th October 1998,
My lord.
this is applicable to the employee.
MDA employees also. It was affected to them also. 40% was, my lord, also provided to these employees.
No, it's a revision of pensionary benefits of state government employees consequent on revision of pay. Is not applicable directly to the KMDA employees.
But it was followed, my lord. The government's decision of enhancement of commuted portion of pension from 1/3 to 40% was implemented to the KMDA pensioners as well. And if your lordship,
so you may submit that this provision as contained in 27th October 1998 clause 6 was followed while framing the rules for KMDA employees.
May I take over? No, this was not changed by rules at all. It was directly and straightway followed. And not persons who opted for 40% pension were paid the balance of this commuted value.
Balance of commuted value,
1/3, 33% one has commuted, raised to 40%. So balance 7% they have also commuted.
So therefore, the enhancement was in the
state government
was following this.
Yes.
This memorandum dated 27th October 1998.
Yes, of course.
But does it ipso facto incorporate the provisions relating to restoration period?
No. Please
If
visualize.
I accept your submission, yes, this has happened. What is being argued on behalf of the state, that in absence of the provisions in the rules, in the relevant rules, that restoration is not automatic.
Please come to page 106 of the writ petition.
Mr. Mujumdar, today I have to rise a bit early because there is a meeting, difficulties there.
You know, I pay for eternity. The government is reasonable, allows its parastatal to be unreasonable.
Well, your junior has taken note.
When the rules provide for,
try to meet the points which have been raised on behalf of the state respondent on the next day. And Mr. Rai, you will take instructions whether in other.
The word commutation, the meaning. That's why it would take on a commutation.
Commutation মানে তো
But whether it is attached, whether this concept is attached with any period.
This commuted value, 15 years.
Commutation means NEWA is known to everybody.
15 years.
Whether this definition includes any period.
No, definition does not. Definition does not. It cannot. Not this has been done very.
But in service jurisprudence, commutation, whenever this benefit of commutation is extended to the retired employees, that comes with a period, prescription of a period for which this amount can be commuted.
You know, this was done by expert statistician, keeping in mind two things. Not one, the average human life expectancy. Number two, the interest component. But when one refunds for 15 years, he does not refund the exact amount. He refunds something more. If I take
5 lakhs of rupees at the threshold, I refund in 15 years probably 7 lakhs of rupees.
But I'm sorry, Manoj, may I just point out, I'm not agreeing to this.
Don't take it, it is on record.
No, the principle which is saying refund, but commutation has got nothing to do with refund.
It has.
No. That is not. The
Because,
concept is not.
because not I take less amount per month from my pension and
Definitely not. Definitely
yes,
not.
yes, you will
But
get
of
your
course
not. Probably he may not be having personal knowledge of pensioners, of course.
That is right.
That is right.
That
He
is
doesn't
right.
have.
I came at first disclaimer.
When a pensioner is entitled to say 50,000 for 40,000 rupees of pension on his retirement and he commutes, he does not take away 40,000 rupees from the next month. He takes 30,000 rupees. That's by way of refund. 10,000 he is refunding. 1/3 of his pension entitlement he is taking less towards refund.
So this commutation is towards refund.
No, commutation he is taking say 5 lakhs of rupees he has taken on superannuation.
Lump sum 5 lakh rupees on superannuation.
Now not his next monthly full pension amount is say 20,000 rupees. So he would have
if there was no commutation,
he would have taken 20,000 rupees, but he is taken 20,000 minus 1/3 of it, say 13,000 rupees.
Yes.
So this is 7,000 rupees he is going on refunding. If I may, and in
or
the
commuting.
or say he's returning the commuted value of pension. Not may I place the government's own language there, as contained in their own pension rules. Now not in for 15 years. When it comes to the 15th year, he does not refund 5 lakhs of rupees. He refunds, say, 6,80,000 rupees. Because that has taken care of the interest component as well.
And then what price the commutation has been made, that is very important. That we are forgetting. Commutation has been done at a higher price. The ratio is there, 1:19.1. That needs to be taken. I'll make my submission. I would like to find that you are
Issue. Matter is heard in presence of the learned advocates representing the petitioner, state respondents, and KMDA and KMD. Next paragraph lists the matter under the same heading as 3 p.m. fixed matter on এই ISC এটা কবে আছে দেখো 13 তারিখ on 20th February, because this court will not be available for some circuit.
But may I make only one humble submission?
As 3 p.m. fixed matter.
Not this has been generated from KMDA's side. Some officer must have given a note or something like that for which not these persons are not getting their full pension. Kindly direct them to produce that before your lordship.
Yes, yes.
Some note must have been written somewhere. Kindly direct KMDA to produce that file before your lordship. They should not be shy of you. Should not be shy of you.
So the note which has been made by on behalf of the finance department.
No, KMDA. KMDA said that it requires amendment, therefore we can't pay, although they supported the cause initially.
They recommended the issue to the finance. So that note you want.
The note by which it was stopped. Let things come to light. No, it's not there. Bring the file. Bring the file.
No, it has already been recommended. It has been submitted on behalf of the petitioner and admitted on behalf of KMD. So the recommendation was more made, but this was the response.
And this is now being sought to be put up as a placard for municipality service as well. Now, this is a warning bell. This is a caution to all pensioners.
Very well, let me see.
Let's go by Friday.
এই এটার মধ্যে রাখো, এটা জেমস লিভ দেখি। আবার কি?
22nd. But the week thereafter, I'm not there on 20th. Sorry, sir. Your Lordship kindly makes it 25th, 22nd.
27th February.
27. Very grateful to you.
এটা না ওই যে ওই একটা ব্যাকশিট করা আছে এটার মধ্যে এটার মধ্যে। ঠিক আছে, very well, let me hear both, otherwise it
Yes,
will
yes,
be
sir.
difficult.
27.
Don't pray for them. এটার মধ্যে রাখো।
তোমার বলা শেষ হয়ে গেছে?
না না তুমি বলবে তোমার
না এটা ওটা না,
আরে ও
change
কিছু
করে
বলে
গেছে। এটা ISC তে
আমি জিজ্ঞেস করবো কি তোমার বক্তব্য, আমি বক্তব্য
ওটা দিয়ে দেবে।
আচ্ছা তোমার তুমিও জানতে পেরে যাও তুমি তো নোট দিয়েছো।